Make leisure lawsuits. I'm submitting this one, right? Make leisure lawsuits.
Yes.
My lord, item number 21, my lord. 21 actually already heard by the court number 2, but it was reserved for judgment. Now it is released because the judge has been transferred, my lordships. I need 2 weeks time, my lord. A date may be fixed.
Okay, as paid for by Ms. K. Devi, learned counsel for the petitioner. Matter stands adjourned for 2 weeks
Consent.
on a date to be fixed by
21 law.
2 weeks, okay? List again after 2 weeks on a date to be fixed by registry.
Yes,
May I
right.
My lord, this is a motion matter, and it was moved on 23/7/2025. And your lordship was pleased to, my lord, adjourn the matter for a week. But by this time, more than 2 weeks have gone, the matter is not coming on Wednesday, my
You approach the registry for that. Okay?
register.
Yes.
Malad, I beg to mention, Malad, item number 1. This item was earlier kept reserved, Malad, and the matter is supposed to be argued by senior Malad K. Chaudhary.
No, which one? Which one?
Malad, for motion.
Which item?
Item 1, Malad.
This reserve.
It was kept reserved in the month of November.
Reserve for what?
Reserved for judgment. By order dated, Malad, can you see?
Item 1.
28/11/2024.
This is motion matter.
Yes. At the motion stage, Malad, this is kept
Oh,
reserved.
oh.
The senior is out of station, but the matter will be taken up next week.
After a week.
After that.
Okay. As paid for on behalf of Mr. K. Chaudhary, learned senior counsel for the petitioner. This is the matter again after a week on a date to be fixed by the registry.
May it please your lordship, with the consent of others, I beg to mention item number 35 of today's list, lordship. In this matter, lordship, the respondents are supposed to file the affidavit. The affidavit is not yet come, lordship. Lordship, I take up the matter in the next week.
Who's for the respondent?
Elementary education.
Elementary education. Any instruction you have received?
That's not fixed.
Sorry, you have not checked. They want adjournment, but the counter affidavit is not filed.
We'll find it. After 2 weeks, madam.
2 weeks?
1 week, lordship. Suspension matter, lordship.
Okay. This is the matter again after a week as paid for by the learned counsel for the petition. Stop registry shall fix the appropriate date. To stop respondents shall also obtain instructions by the next date. All right, you submit on that day?
Fine.
It'll come after a week.
Obliged.
In item number 3, my lord, I have filed an affidavit in reply, my lord. Now, may I prefer call for the same, my lord?
3 and 4 are clubbed together.
Yes,
They're similar matter.
similar.
Okay. Affidavit, all that.
May it please, my lord.
Yes.
Prayer for listing of a motion matter, my lord, on Thursday, my lord, if it pleases my.
Please approach the registry.
My lord, there is an urgency in the case, my lord. Why
You-
speaking?
You impress upon the urgency, the registry, they'll list it. Okay.
I am deeply obliged.
May it please the lordship. Lordship, with the consent of either side, I recommend item 56, madam.
56.
This matter may take up after 10 days, madam.
Lordship, there is some urgency, Lordship, in the matter. The petitioner is being barred from signing in the registry.
Hmm.
Kindly, after a week, Lordship, a date may be fixed.
There's a review petition also.
Yes, Lordship. We have filed the review petition.
Order is passed by this court.
Yes, Lordship, we have filed a contempt petition. They have filed a review petition for reviewing the order of the in the writ petition, Lordship.
I'm repeating the question. The order in the review petition is passed by me or somebody else.
Review petition. Uh-huh. That's what it is.
Just check the order. Give me the review petition. After 1 week,
Date might be maybe.
it is not by me. That much you don't know. This matter, as paid for by the learned counsel for the as paid for by Miss S. Sutia, learned standing counsel, elementary education department, and not objected to by the other side, list this matter again after a week on a date to be fixed by the registry. Yes, next.
Everything for listing on motion matter. There's some urgency.
Motion matter, you approach the registry. Okay?
My lordship.
Yes.
Lordship, with consent of the respondent government council, I beg to mention item 44, lordship. In the IA, affidavit in opposition has been filed, so we'll be filing rejoinder, lordship, finally. Matter will be taken up after 2 weeks, lordship.
Rejoinder in the IA.
Yes, lordship. They have filed affidavit in opposition, so we'll be filing rejoinder, lordship.
Who's for the other side?
Government council remains there, 44.
Your good name?
NZ Chaudhary.
As paid for by Mr. NZ Chaudhary, learned counsel for the petitioner. Matter stands. I'm talking about NZ Chaudhary. Just a minute. Why GSM?
So JSM remains the opposite.
Wait. As paid for by Mr. NZ Chaudhary, learned counsel for the applicant, petitioner. Writ petitioner,
Yes, lordship.
applicant stroke writ petitioner. Matter stands adjourned for 2 weeks to enable him file rejoinder affidavit to the affidavit in opposition, file in the IA. Stop list again. After 2 weeks on a date to be fixed by the registry. All right.
Much obliged, lordship.
Please, your lordship.
May it please your lordship, taking consent from the other side, I beg to mention item number 42 and 43 of Delhi list. I am appearing on behalf of my learned senior Ayat Sekia. We must respectfully seek for adjournment of 2 weeks to obtain up-to-date instruction from the client, subject to your lordship's convenience.
Yes, anyone?
I am appearing on behalf.
Any objection?
Secondary education, your lordship.
Let's wait for on behalf of Mr. Ayat Sekia, learned counsel for the review petition, and not objected to by the other side. List the matter. After 2 weeks, on the date to be fixed by the registry. Ms. P. Das, learned secondary, learned standing counsel, secondary education, FBS for the respondent department. Yes.
May it please your lordship. Lordship, readings are completed in this matter, your lordship. So kindly matter may posted for hearing.
No date, registry will give a date, on a date to be fixed by the registry. And in the, and the admission column, correct? Okay.
Deeply organized.
Yes,
My lord, in regard to item number 61 and 62, lordship of the supplementary list, lordship. My lord, these matters are actually impleadment applications, lordship. Lordship, on the last occasion also, it has come up on the column where order for impleadment is to be passed. But today it has come up in the admission column. May I pray your lordship, this matters be taken up after the impleadment item, that is item number 13, if your lordship permits. Otherwise, it's a application for impleadment, lordship. On the
61.
last, yeah, 61 and 62. Just for praying for upgradation, lordship. If it may be called after item 13, lordship. Item 13. Item number 13 is for order for impleadment of parties, lordship. After that item, if this item may be called,
okay.
deeply obliged.
May it please your lordship.
Lordship, I'd like to mention item number 26, lordship. We'll be filing a rejoinder in this.
How much time?
1 week's time, lordship.
1 week's time is granted for the petitioner to file a rejoinder affidavit as paid for. List again after a week on a date to be fixed by the registry. Yes.
In item number 15, lordship, lordship may permit to withdraw this petition.
15.
We are the petitioner.
IA is also filed by you.
No, 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 sir. I'm the main petitioner.
What is the IA for? Name of the petitioner,
I'm for the petitioner, sir.
name of the petitioner, name of the petitioner,
Name of the petitioner, Supratik Date.
and others.
Yes.
Three of them, isn't it? They want to withdraw.
Yes, Lordship.
Yes, opposite party, anyone? You're not there.
Item number 15.
Second, yes, your lordship, I'm appearing on behalf of secondary.
They want to withdraw.
Yes, your lordship.
I'm the applicant.
I'm not.
I'm the applicant. Also, the matter strikes at the very heart of the petition because the title suit that they are claiming title from is actually on a concealed fact that the property was already donated by a trust.
Today they want to withdraw it.
My lord, my application is there. The
Applications for what?
writ petition is not, application is for impleadment and
Implement,
number
yeah.
6.
Your lordship, already the matter is going for not pressing your lordship. It is for withdrawal.
I know, please don't interrupt. Ms. Pidas, I understand. See, they want to withdraw the writ petition. What objection can you have?
My lord, let them file a separate application for withdrawal.
Is it required? Court can always grant leave. Where's there?
My lord,
What is the problem?
discretion is there. My lords, I press for that the matter be dismissed with cause. Because this court has been misled.
No, Lordship, we tried.
Title has been obtained surreptitiously by virtue of a compromise, my lords, without informing the honorable lower court that the property had already been donated. The 2 acres of land that they're claiming execution for has been donated, my lords. That fact has been hidden from the lower court pleadings, my lords.
Yes, ma'am.
Lordship, now, school is running under our control. Then
What
we want just this petition, we want withdraw this petition.
Why did you file in the first place, the writ petition? For what?
For what, Lordship, actually, my senior is not available today. And all facts are not available.
No, if you are,
But,
when you are,
But petitioner not want to pursue this petition, writ petition.
no, that's a
Then,
different thing.
Permit for the withdrawal.
Well, I may answer, my lords. I may satisfy.
I quit.
I may satisfy.
I'll file that withdrawal petition. Lordship, kindly permit. I'm for secretary.
We'll allow withdrawal, but there will be no liberty.
Lordship,
Your,
Lord, I
what,
press for withdrawal with costs.
your good name?
H. Devi,
H,
Devi.
your name is not there? Devi.
Oh, yes, Lordship, on behalf of J.I. Bormia, sir. Sir is not today, my senior is not available today, that is why.
No, your name is not there. You're not in the case. You have not signed Vakalatnama.
Lordship? On behalf of,
You have not signed the Vakalatnama,
no, Lordship.
and you're mentioning on behalf of somebody for withdrawal. Hmm,
J.I. Bormia. My senior, J.I. Bormia.
I understand that.
Definitely is the court, my lords.
Hmm.
Let the interlocutory application be allowed for today, and then they'll file a separate application for withdrawal. If they have no objection, then the application will be allowed for impleadment. That's just one of the-
Your eye is for impleadment of parties.
Yes.
Impleadment of party, yeah. Anyway, it's a writ petition filed by them. When the writ petition goes, there's nothing left in the eye.
The authority is not there.
Hmm.
Authority is not there. Lords.
No, she's submitting on behalf of our senior, J.I. Bormia. Your name?
H. Devi.
Miss H. Devi, Learned Counsel, submits that she has been instructed by her senior, Mr. J.I. Bormia, to withdraw the matter, since the petitioners no longer wish to press the matter. Stop. Your good name?
My name is Divine Banerjee, Lord.
D. D Banerjee.
D Banerjee, I'm appearing on behalf of the
Which respondent?
respondent number 6, Lord. But we are the applicant. We were supposed to be impleaded, Lord.
Oh, you were supposed to, you're not yet impleaded.
I'm not yet.
Oh, that is a different thing.
Because if I may submit.
Ms. P. Das, Learned Standing Counsel, Secondary Education, has no objection to them there. In view of above, writ petition stands dismissed as withdrawn.
Lord, if I may submit.
Deeply obliged.
Lord, if I may submit on this application.
Disposed of. Next.
May I please your lordship?
Yes.
My lord, with the consent of my lord other side, item number 16 and 17, my lord. Item number 16 and 17, my lord, in item number 16, I am the respondent, and 17, my lord, I am the petitioner, my lord. My lord, we are required to file, my lord, an additional affidavit to bring certain developments before my lord, 16 and 17. So, my lord, at least 2 weeks' time is required, my lord.
I am appearing, your lordship, on behalf of second.
And you are there in item 16 also?
Yes, sir.
Connected matters. my lord.
No, no. Mr. Bhuya,
My lord. Yes, my lord.
you are in item 17, your name is shown.
So, my lord,
Then in 16 also you are there.
I am there, my lord. Both matters.
Oh, but you are for the respondent.
My lord.
In one case, you are for the respondent.
My lord, one case I am for the respondent in item 16, and for the 17, I am the petitioner, my lord.
So you are submitting on which case?
My lord, in item number 17 on behalf of the petitioner.
Okay. Mr. A.R. Bhuya, Learned Counsel, appearing for the petitioner in WPC number 6312 of 2021. Submits that he may be given 2 weeks' time to file additional affidavit
My
to incorporate the
subsequent development.
subsequent developments in the matter. The prayer is allowed. List the case again after 2 weeks on a date to be fixed by the registry.
My lord. Obliged. I love that.
May I please, your lordship, I beg to mention item number 60, lordship.
60.
Yes, lordship, supplementary in this. Lordship, kindly agenda method for the day, lordship, and in course of the time, I will take step, lordship. Okay.
Hmm?
60.
I am appearing, your lordship, here. The
Steps not,
no step has been taken, your lordship.
Which respondent? Which respondent?
lordship, I'm unable of the tech,
You
lordship.
should check the file before making your submission.
Lordship,
Respondent.
Respondent number 4 or 5.
petitioner.
check up.
lordship.
She is bringing.
Petitioner, lordship.
I know
Yes,
you are for the petitioner. You have failed to take steps.
yes, lordship.
You are praying for some time.
Yes.
I'm asking you which respondent. You don't know. So we'll see the file now. You're wasting the time of the court.
16, 6.
Right, okay. As paid for, further 3 days' time is granted to the petitioner to take steps on the respondent number 5 by registered post with AD due. List again after 2 weeks on a date to be fixed by the registry. Mr. P. Das, Learned Standing Counsel, Secondary Education, request for the respondent department. Yes.
Deeply obliged.
May I please also? So, I beg to mention item number 53, lordship. I'm for the petitioner. Paper password for the date. I've taken consent from the other sellers.
On the request for the, by the Learned Counsel for the petitioner, matter stands password for the day.
Lordship, deeply obliged.
53.
May I please, your lordship?
Yes.
This matter pertains to payment of arrears salary. For the last almost 20 years, since the month of May 2006. I'm the assistant teacher. I've been regularized, post is regularized. My salary, time scale salary confirmed. Without any reason, I didn't receive my salary.
Why come now? Salary you're not getting since 2006. Why are you coming after so many years?
I have been regularly attending your lordship, the school, despite not being given the salary. And the stability situated is the order of this honorable court.
Yes.
May I bring your worship, kindly notice maybe in this matter because they are all illegally appointed people. Minor
No
and
reason is given here. For this, for holding up the salary, no reason was, no valid reason was given.
You still have not answered my question. I'm asking you, why have you come after 20 years? Since 2006, you're not receiving salary.
In 2000.
How are you surviving?
Your
You're
lordship-
working elsewhere.
No, your lordship. In 2021,
Heard your good name?
my name is A. Narzari, your lordship.
Mr. A. Nazari, learned counsel for the petitioner, who submits that petitioner has not been paid salary since the year 2006. Stop. It is not understood as to why the petition has come after so many years, if salary was indeed not paid since 2006. Be that as it may, let the notice of motion be issued, returnable by 4 weeks. Miss
And
N. Fugan, learned standing counsel.
respondent 1 to 4.
Your secondary or elementary education, except notice on behalf of respondent number
1 to 4.
1 to 4. Anybody else? Accountant General, Mr. B. Sharma, standing counsel AG Assam, accepts notice on behalf of respondent number 5. What about 6 also? Senior accounts. Okay, make it 5 and 6. Notice is therefore complete. Petitioner shall, however, furnish requisite copies of the writ petition to the learned counsels for the respondents appearing today within 2 days.
This matter is allotted to Mr. B. Chakraborty, the last standing counsel for the AG. There are 6 standing counsel for it.
Whose name should we record?
B. Chakraborty.
Okay, record B. Chakraborty.
Keep level.
Highly obliged.
My lordship. This is a peculiar case, lordship. It is an impugn order, lordship. I have annexed in the impugn order that page. What happened in this case? That is on page 18. Here, all the teachers are assistant teacher, all assistant teacher. So by page 18 date 7/7/25, one transfer order has been issued. Lordship got it. Page 18.
Transfer matter.
Last person. That's it.
Page 18.
Page 18.
You should have enclosed the typed copy.
That's it.
It's not very legible.
Secondary नाम लिखो ना, no?
Yes, Mr. Raman.
Yes, look, page 18, where, let's see, one assistant teacher was in charge of the school. He was been transferred by this order 7/7/25. And in the same order, it was directed Sorab Ali to hand over the full charge to the senior most teacher to the school and which is new place of posting. So he was transferred, then charge was handed over to me, petitioner before your lordship. So I have taken over charge on 11/7/2005, page 20. Page 20.
Charge of?
Charge of the headmaster.
Of which school?
That the
Headmaster of which school?
Rajabari ME school. Headmaster. So I have taken over charge on 11/7/25. That is temporary. Then by the order dated 31, by page 31, this is again another master is handed with this directive to be taken over charge. So he is also in charge, he is also in charge, he is also temporary, he is also temporary. So my principle is that one ad hoc cannot be substituted by another ad hoc. So here the same thing is happened. So I am an assistant teacher. I was allowed to hold the charge on 11. So therefore another order has been issued by, that is Annexure 4 page 31 for 3 months. Very interestingly, kindly Lordship peruse the order. As per proposal of Block Elementary Education Officer so-and-so, Noor Mohammed, assistant teacher of the school, is hereby allowed to hold the charge of headmaster of the school temporarily in addition to his charge. Teachers with the authority to draw the disbursement, drawing and disbursement slip for 3 months with effect from 8/7/25 to 30/9/25 or till the then. So my humble submission before the honor that one person cannot be substituted, the ad hoc cannot be substituted by another ad hoc. So I am, if permanent headmaster is appointed, I have no objection. That is my case.
Page 18 is the order by which you have been allowed to hold the
Yes.
in charge.
Charge, yes.
Rajabari
Rajabari,
Sologuri, ME School.
yes, MA school,
And by page 31,
yes.
private respondent.
Private respondent, he was allowed to hold charge. For 3 months, same thing, for 3 months.
Otherwise, your
No, if permanent headmaster is appointed, I have no grievance. But here, same rank of teacher, assistant teacher, he is also assistant teacher. So I am taken over charge temporarily. He is also allowed to hold the charge for temporary. What is this, Lordship? So here I like to refer one judgment of our High Court division bench judgment that ad hoc cannot be substituted by another ad hoc. This is the judgment, Lordship.
no, that's a settled principle.
Yes, Lordship.
Okay. Now, question is, as per page 18,
Yes.
you are allowed to hold the charge for any particular period of time?
No, temporary,
No period.
no period.
But by page 31,
Yes,
it's what, 3 months?
3 months. And 3 months I have completed.
What is the date of the order?
My order is that is, say, I have taken over charge on 11/7/25, page 20. Now, from 11/7/25, I am holding the charge.
And this impugn order is dated?
Dated, impugn order is 21/7. 21/7/25. So I have already taken over charge 11/7. I am continuing.
Yes, anyone? Elementary.
Yes.
Part Mr. H. Raman, learned senior counsel, assisted by Mr.
Yes, I meant.
S. Ahmed for the petitioner who submits that the petition is agreed with the order dated 21/7/2025, bracket annexure 4, by which the respondent number 4 has been asked to hold the charge of in charge headmaster
For the period 8/7/25 to 30/9/25.
Name of the school is not given.
Here, this order is
Of Rajabari Sologuri ME School
MA school.
for the period with effect from 8/7/2025 to 30/9/2025
Or till the joining of a regular headmaster.
or till the joining of the regular headmaster.
If regular headmaster join, I have no grievance.
Full stop. Okay, Mr. Raman,
Yes.
if you see the order,
No.
this respondent number 4 is allowed to hold in charge headmaster of which school?
That is not mentioned here.
So,
In the order sheet, it is non-contemptible, but here it is.
How do you know that this is against your school?
No, it is a copy four, the next page, page 32, four. Real 4, Nur Mohammed assistant to the Belkli same school. That is mentioned here.
No,
No, that, yes, I don't understand because.
that is what? Bel?
Page 32,
No, that is Beltoli School.
Belkli school is.
We're not concerned with Beltoli School.
No, same school. Also.
Rajabari, Sologuri and Beltoli School is same.
Same.
How can that be?
That was, that in or they
One
are.
school having two names.
No, in order, Lordship, it is, I have seen the order, it is defective,
this
defective
is-
order. But copies are, so Nur Mohammed is.
Next para. It is however seen that the impugn order dated 21/7/2025 does not mention the name of the school to which respondent number 4 is supposed to be the in charge headmaster. Be that as it may, let notice of motion be issued returnable by 3 weeks. Miss so-and-so, Learned Standing Council, Elementary Education accepts notice on behalf of respondent numbers
1 to 3.
My
one,
position may be.
2 and 3.
Status quo is up today may be mentioned.
No status quo.
Taking.
Petitioner to take steps for service of notice upon the respondent number 4. Learned Standing Council shall obtain instructions with regard to the discrepancy about the school not having mentioned in the impugn order by the next date.
Order is defective, Lordship. I have seen the order, but they have not in order, they have not mentioned, because it is the order.
Since it's defective, don't give the charge. Don't give charge. There's no name, there's no mention that you come to my school.
Yes, but only in a copy served with item number 4, they mention this school. In the order, it is not there.
Next case.
Dibler.
May I please, the lordship, my lord, before my respected senior friend starts, my lord, I have the instruction and have the power, my lord, to appear on behalf of the respondent number 4.
So,
So, my lord, I may be heard, my lord.
so you want to move the motion?
No, my lord, motion will be moved by my respected senior friend. Only, my lord, if any interim order is going to be passed, then I may be given the opportunity, my
My
lord.
lord, I am there, my lord. Let him be heard also.
Mile.
Let him be heard also. Let him be heard also, my lord.
Okay.
My lord, I take your lordship to page 25. Page 24, judgment order starts, where, my lord, the respondent, private respondent herein approached this court.
Yes.
My lord, the second paragraph, the petitioner was appointed as science teacher in such and such school, Nagaon, issued by such and such, in which he joined the said post on 93 itself, and since then he is receiving graduate scale of pay. Such school was amalgamated with such school, another provincialized school of the state by order dated 2017, issued by the Director of Secondary Assam, and thereafter the service of the petitioner was brought under the Director of Secondary Education Assam, within the jurisdiction of Inspector of Schools such and such Nagaon. The Director of Secondary Education Assam, by the order dated 2019, deputed the petitioner to undergo B.Ed course in such and such Nagaon for the academic session, and the petitioner completed his 2 years B.Ed course in the month of September 21. The petitioner stated that the respondent number 5, an assistant teacher, respondent number 5 is the petitioner here in matter. As assistant teacher who is already holding the post of headmaster in charge of the said high school, though received graduate scale of pay in 95, but he does not have the B.Ed degree. As such, the said respondent number does not have the eligibility to be a headmaster in a provincialized secondary school. By placing the seniority position of the teaching and non-teaching staff of such a school after its amalgamation, Custody High School that was forwarded by the Inspector of School Nagaon District Circle Nagaon to the Director of Secondary Education Assam in 22, the petitioner stated and said respondent number 5 is junior to him and the said respondent received graduate scale of pay 2 years later to him. It is contained in the petition that since the respondent number 5 does not have the B.Ed degree, does not possess the eligibility to be the headmaster of any provincialized school of the state as provided under the Act. In this regard, such as the judgment, relying on the provision of such and such submitted that senior of the respondent number 5 and has all the requisite eligibility to the headmaster of the section 7. After hearing the learned counsel, in the event of filing in such representation by the petitioner within the time so specified after giving an opportunity of hearing to the petitioner, as well as the respondent number 5 and considering the relevant records of the inspector of schools, the director of secondary shall dispose of the said representation of the petitioner with speaking order, intimating him about the outcome of the same. So, my lord, I was allowed to hold the in charge of the headmaster, and he being the B.Ed holder, admitted fact, my lord, I don't have the B.Ed. That is a admitted fact. And my lord, now the next order comes at page 9823. Consequent upon the expiry of the present headmaster, page 27, my lord, 27, sorry, 27. Page 27, next page.
Yes, yes. Read.
Consequent upon the expiry of the present headmaster such and such, the inspector of schools submitted a proposal for placing a new headmaster in charge. Upon verification of the seniority list, it was found that Mintu Kokoti, the private respondent hearing, was the most eligible senior teacher, but Mintu Kokoti submitted a prayer petition showing his unwillingness to hold the charge of headmaster in charge. As a result, in the interest of public service, another teacher, Abdul Matlib, the petitioner herein, who is the next senior most after Mintu Kakoti, was allowed to hold the charge of headmaster in charge of Kasturi High School. Later, Mintu Kakoti filed a WPC claiming his seniority over the other teacher of the school to hold the headmaster in charge of such and such. In the interest of public service, decision was taken in favor of next senior teacher. To allow him to hold the in charge headmasters, Mintu Kakoti submitted a petition showing his unwillingness to hold the charge of headmaster. As such, Mintu Kakoti lost his seniority over the other senior teacher of the school. Hence, Mintu Kakoti claim for seniority over the present headmaster in charge, Abdul Matlib, cannot be considered. Now, my lord, the next page, he files a writ petition against this. He files a writ petition in this against this order, which was ultimately withdrawn by him, my lord. That was WPC 289124. 2891, he approached this court against that order, 2891. There was no stay order. I think my instruction goes, there was no stay order. My lord, then thereafter, this impugn order comes. From bottom, I will take your lordship. Above the other things, I will not read, my lord. This was passed on 29/7/25 from last, whereas in response to office letter dated such and such. May I read it, my story? Page 28, the impugn order.
Yes.
Whereas in response to office letter dated 21/5/25, the inspector of schools Nagaon such and such submitted the first seniority list of teacher of Kasturi High School Nagaon. Now, upon perusal of seniority, it is found the Mintu Kakoti assistant is the most eligible teachers to hold the charge of headmaster. In view of the decide to allow Mintu Kakoti to act as in relieving Matlib of the headmaster in charge from the charge. So I was removed. Now he has been placed again. And this writ petition, which was filed by him, was withdrawn. My submission before your lordship is this: go for a regular selection. Why one in charge, one after another is going on? Go for a regular selection. That is the prevalent law of the division bench of this court. What was submitted by him also. Go for a regular selection. Why not? I am not eligible. I do understand, man. I am not eligible. I admitted fact. I am not going to suppress or say that I am eligible or something like that, man. But one thing that has to be taken into consideration, my lord.
But what about this page 27?
Page 27, that is also, my lord. He has filed a representation. He lost his seniority.
No. He says that he submitted petition showing his unwillingness to hold charge of the subject.
If I submits an application that I will not try to take the whole in charge. Now again, he files against this order, he files a writ petition. That writ petition, he ultimately, when this impugn order comes, he withdraws that writ petition.
Okay.
My lord, this division bench, and my lord, I'm just placing that, my lord, page 50 to 2065.
And page 24, which you read also, this is by him, by respondent number.
My lord, page 25 that I have read.
Yes.
That was by him,
Representation was for what? For being in charge principal
my lord.
and headmaster.
Headmaster, my lord. And ultimately, that was decided that he has given an application that I am not willing to go to hold the post. So that was, and that by the law, he loses his seniority. Now again, what they are doing, that my lord, your lordship is well aware of PRSA. Ad hoc is replacing by ad hoc. There may be a question. What is your locus? You don't have a BL. You cannot compete for the regular selection. That is also admitted fact. My lord, my prayer is this. I have been given a charge. I have been holding the charge. Suddenly he is unwillingly. If he is not senior also, he is not also eligible. If he is not senior, both has to be taken into criteria. Seniority and eligibility. I don't have a locus, then also he cannot be considered. Because the impugn order says, now upon perusal of the seniority list, it is found that the Mintu Kakote BSc is the most eligible teacher. But they are not saying about the seniority. Because in the impugn order, last but third paragraph, now upon perusal of the seniority, it is found that Mintu Kakote is the most eligible assistant teacher. But they are not saying, because it is an admitted fact. The rule says the moment you forego or you go for a own request transfer, then you lose your seniority. That is their document, my lord. And this document was not set aside by the court. That order of at page 27 was not set aside. I am asking for a regular selection. Now, this is the judgment, my lord. You will look into. Page 50. This is the division bench, my lord. Look. Division bench judgment, my lord. And he has come after 6 years, man. But ad hoc is going on replacing by ad hoc. This will continue for a. Whether this order of page 27 was set aside, I don't know. It is to eligibility.
The requirement is
B.Ed. It is true.
graduate in arts, science, commerce with BT or B.Ed.
B.Ed. My lord, that I don't have. I admit it, my lord. There is no, because my seniority list itself shows that your lordship will look into at page 20. Your lordship will look into page 20. Serial number 4. I am BSc. I cannot compete for a regular. There may be a question. Where is my locus? If I cannot compete, but only thing, my lord, he has said that I will not go for the post. Then suddenly, the seniority list was provided and said he is the eligible. But I was continuing. Let them go for a regular selection. I may be continued for the till then there. Or if at all, my lord, they need in urgency, let the inspector of school run the school. And in the meantime, my lord, they'll go for a regular selection. Why ad hoc is always replaced by an ad hoc?
Where is the order by which you have been given the charge?
My lord. Here, my lord, page 27.
Okay, 27, yes.
Because it is their statement that he loses his seniority on being, and that was not set aside by a judicial order, because that order was withdrawn, as far as I know, man. Dismissed on being infructuous.
That is the writ petition filed by him.
My lord. Writ petition stand dismissed on being infructuous.
Okay, that's your case.
That's my submission.
Yes.
May I please as your lordship? My lord, for the post of, my lord, holding the charge or for the purpose of regular selection and appointment, this honorable court has, my lord, already settled, my lord, in a catena of judgment that for the purpose of holding the post temporarily also, an incumbent is required to have the degree for the, my lord, regular promotion. Now, my lord, my lord, the client which is represented by my respected senior friend has admittedly do not have the BA degree. Even then, my lord, he was succeeded to continue to hold the post for more than several years, my lord. Now, here is a case, my lord, what has happened, my lord, I have to submit fairly before my lord, my lord, for a personal difficulties in my family affairs, my lord, for the purpose when the regular headmaster was, my lord, superannuated. Then, my lord, the department wanted to give me the charge of the office of the headmaster of the present school, my lord. But for the purpose of that difficulty, for a temporary period, I have said, my lord, by way of a representation that at this moment I am not, my lord, mentally fit to hold the charge, my lord. That's due to the death of my family member, my lord, very near one. But, my lord, when this issue was over, my lord, and when, my lord, I have got the BA degree, my lord, I am in the entire, my lord, cadre of the graduate teachers, my lord, I am the.
Just a minute.
My lord.
You say that when I got the BEd degree, that means you did not have the BEd degree earlier also.
No, my lord, that order had been annexed by my learned friend, my lord. My lord, maybe.
No, when the offer came to you, that time you did not have BEd.
No, I have that time also the BA degree.
Okay.
I have the, my lord, subsequently, after my inductment in the service, I got the BA degree. But when, my lord, this man was given the charge on my refusal, my lord, at that time also I have the, my lord. At that time also I have, my lord.
No,
Now-
just for a moment, page 27, Mintu Kakoti BSc, third line, page 27, Mintu Kakoti BSc. On 23, my lord, your
No,
lordship.
my lord, I have the instruction and I have filed a writ petition before my lordship's, my lord. That writ petition was closed on withdrawal
Third line,
because, my
page
lord,
27.
my lord, in
Mintu
that,
Kakoti BSc.
if my lord may be pleased to take up my lord, that closed writ petition along with this, the present one, my lord, it will clarify the entire story, my lord. My lord, why I should submit unfairly and submitted a misleading statement, my lord. I cannot, my lord. When I lose the case, my lord, I will not mislead my lord, my lord. It is a very clear instruction that I have the BA degree at that relevant period of time, my lord. That's why I have been proposed to take over the charge, but for certain reason I could not, my lord. Now, my
No,
lord, this
see,
situation,
nobody is doubting your thing, but since you have made a statement,
my lord.
you had made a submission. When I came to have the BA degree, that's why I was asking you.
That's why, my
That
lord.
means, that's why I asked you whether you had BA degree from before or later
No,
on.
I have the BA. It is my bona fide.
Nobody is questioning you.
No, my lord, it is
You
my.
had made that submission, that's why I asked you.
My lord, it is my bona fide mistake. That may be pardoned me. My lord, what has happened, my lord? Now, presently, the issue is very clear, my lord. Open and shut. This man, my lord, who is the present petitioner, do not have the BA degree, and the requirement of the rule 14 of the, my lord, secondary education rule is very clear, my lord, that the BA degree is a mandatory qualification for the purpose of regular promotion as a headmaster of a high school, my lord. But this, my lord, present petitioner do not have. Now, my lord, when this person was given the charge, my lord, I did challenge, my lord, that conferment of charge, which is at page 27, my lord, by of a writ petition. Then subsequently, my lord, this speaking order, which is now under challenge at page 21, had been passed during the pendency of my writ petition, my lord. That's why, my lord, a statement had been made that, my lord, as the relief had been granted by the, my lord, department. That's why, my lord, there is no issue, my lord, keeping the pending of that writ petition further, my lord. Because the order which I am impugned, that has already been interfered with by the department, my lord. That's why the writ petition was closed on withdrawal, my lord. That's the issue. Now, my lord, the issue is very clear. If we go by the seniority list also, my lord, then there is no incumbent except me at this moment, my lord, to hold the charge of the headmaster of the school. Now, my lord, it is not a right of anybody that who can go and claim that I should be given the charge. Now, my lord, may kindly see, my lord, their prayer. In that prayer, they have my lord, prayed for a mandamus from my lordship at page 17, my lord, prayer number 3, my lord. Prayer number 3, my lord, I am back to draw my lordship's attention, my lord. A writ in the nature of mandamus shall not be issued to allow the petitioner to remain as in charge headmaster in so and so school, my lord. Is it possible, my lord, a person who do not have the BA degree, how the department can allow, my lord? The law is well settled by the division bench of this honorable court also, my lord. If my lord may be pleased to take up the order of this honorable court, my lord, which is that, which has been annexed in the petition itself, my lord. Just, I would like to draw my lordship's attention, my lord, is at page 26, my lord.
Yes.
My lord, in this page 26, my lord, I am reading paragraph 3, my lord. In that regard, Mr. So-and-so, the learned counsel for the petitioner, placed before the court the relevant judgment passed in the case of Jagannath Pegu versus State of Assam and others reported in so-and-so, as well as a division bench judgment passed in the case of MD so-and-so and so-and-so in 2016 5 GLR 52, my lord, wherein this honorable court, my lord, has categorically clarified that an incumbent who do not possess or have the degree for the purpose of promotion in the next higher cadre, my lord, cannot hold the post temporarily for a second, my lord. Now he is fortunate, my lord, he has already hold the charge without the degree for more than 4 years, my lord. So therefore, my lord, at this moment, as I am the only eligible and qualified person in the school, looking into the interest of the students also, my lord, a B.Ed qualified headmaster is required, my lord. That is the mandate of the rule, and the judicial precedents favor also me, my lord. So therefore, my lord, at this moment, this order has no, my lord, my lordship, as I have already taken over charge, my lord, from the office of the inspector of schools, my lord. If this order is going to be interfered with, my lord, then there will be again some disturbances there, my lord. My lord, may issue notice at this moment, my lord, I am, as I have already hold the charge, my lord, have the instruction, my lord. And there is no scope of interference, my lord, in this order.
Okay, why a regular headmaster is not being appointed?
Look, the exercise.
What is the
going on,
problem?
my lord. Exercise is going on. In some of the cases, my lord, I am also appearing for the purpose of promotion. One interim stay order is there, my lord, in the entire state operating, my lord. That's why this process has not could be finalized yet.
What is the interim order?
Interim order is, my lord, that the result of those, my lord, selection and promotion has been directed not to be declared without the leave of the court, my lord. My lordship has taken up that matter a few days back, my lord. That CMJ University matter, my lord. Mr. B. Kaushik has given a division bench order to my lordship has decided to peruse the same. Sanatan Talukdar case.
This is a stay order.
My lord, my lord. So, my lord, therefore, my lord.
That has become an impediment in filling up the post of
My lord,
headmaster.
my lord. What's going on? My lord.
When is it fixed?
Date to probably. My lord, I will apprise the date, my lord. It is coming in the next week. So, my lord, at this moment, my lord, my respectful submission before my lord is that, my lord, if an incumbent who do not have the B.Ed degree, even he cannot compete for the regular selection also, my lord. That is the position, my lord. So, my lord may issue notice, my lord, without interfering with my respectful submission, my lord, that this order does not call for an interference, being a, my lord, very, my lord, just and reasonable order, my lord.
All right.
My lord, may I reply to that, my lord? They say, my lord, that the seniority list shows that he is the eligible teacher. My lord, that seniority, after he loses the seniority, where does he get, my lord? That impugn order says, now upon perusal of the seniority list, it is found is the most eligible assistant teacher. Whether he is the senior most there, and no other person of holding a B.Ed teacher is there. Whether that was there anything has been shown before this in this order. Now upon perusal of the seniority, it is found he is the most eligible assistant teacher. Seniority and eligibility does not say anything about the seniority here. And I have not handed over charge, my lord. I have not handed over charge.
He should, my lord, because he is underqualified, my lord. Should immediately, my lord. He should immediately hand over the charge to me, my lord.
No, that again contradicts your submission.
Status.
No, my lord, my
Mr. Bhuya,
my lord.
just some time back you submitted that you have taken charge.
I have taken over charge from the office.
Now you say that he should inform
me
charge.
Submitted, my lord. It is on record, my lord. I cannot lie, my lord. It is from the office of the inspector of schools. I have taken over the charge, my lord. I have submitted before, my lord. Just few minutes.
Then why do you say that he should hand me the charge now?
No, because, my lord, all about the record.
Which contradicts your earlier statement that you have not been given you have already taken the charge.
I have said, my lord, that I have taken over the charge from the office of the inspector of schools, my lord.
Are you meaning to say that you have assumed charge?
Yes, my lord. Yes, my lord.
From the inspector of
From the
schools.
inspector. of
But I am still holding the post of headmaster in the school.
My lord. Huh? Morigaon. No, no.
But that order, my lord, your lordship will find at page 27, which says that he has recused himself from taking the post. For temporary nature, whatever it is, my lord, he has lost his seniority.
All
Okay,
right.
he is in the
My lord-
bottom of the list of the
My
seniority.
lord, that.
Okay, I've heard parties, so today we'll issue notice and interim also notice. On the next date, we'll consider interim.
I'll file
Whatever,
next day.
But
you get the instructions.
But in the meantime, my lord, he will pressurize us, throw me out, then the case become infructuous.
No.
Otherwise, we'll let the inspector of schools run. If their case become infructuous, there is
No,
nothing else, my lord.
inspector of schools cannot be given the charge.
My lord, then otherwise status quo order, my lord.
No.
It will
Status
create-
quo order,
it will
because he
create-
says himself that I am not handed over charge.
No, it will
Then
create-
otherwise, this case will become infructuous. What is the requirement, my lord?
Heart, mister. Your name is not there?
No,
P.K.
my
Roy
name is
Chaudhary?
not-
P.K. Roy Chaudhary, learned counsel for the petitioner who submits that by filing this writ petition, the petitioner has challenged the order dated 29/7/2025 bracket annexure Roman 7, by which the respondent number 4, is it?
My
Yes, my lord. I am for 4, my lord.
Respondent number 4 has been temporarily allowed to act as the headmaster in charge of
My lord, Kasturi High.
Kashori High School, Nagaon, with financial power to draw and disburse the salary, etc. In addition to his normal charge as assistant teacher. Stop. The learned counsel submits that the petitioner was given the was allowed to be the in charge headmaster by order dated 9/8/2023. And therefore, he could not have been replaced by the respondent number 4
On an ad hoc basis.
on ad hoc basis. Since it is in violation of the established principle of law that an ad hoc cannot be replaced by an ad hoc appointee. Learned counsel also submits that the petitioner had earlier declined to be the in-charge headmaster of the said school. And therefore, the impleadment order dated 29/7/2025 should be set aside.
Your lordship, one thing, my lord, if your lordship is issuing notice on both without giving an interim protection, your lordship may ask the government to produce the seniority list on the very next day, my lord. If it shows that observation may be there, other senior persons are there, then this order will go. The other senior person, eligible senior person is there, then there is an extraordinary control.
Senior with B.Ed.
With B.Ed, then this is an extraneous consideration is flowing.
In view of above, issue notice of motion returnable by 4 weeks. Mr. S.M.T. Chisti, learned standing counsels. Secondary education accepts notice on behalf of respondent numbers 1, 2, and 3. While Mr. A.R. Bhuyan, learned counsel, appears for respondent number 4. To stop. Notice is therefore complete. Stop petitioner shall furnish requisite copies of the writ petition to the learned counsel appearing for the parties today, within 2 days. Also issue notice on the interim prayer, returnable by. Will have an earlier date,
Yes, earlier. 2 weeks.
within 2 weeks.
Yes.
Give a date after 2 weeks. Give
Yeah. 28.
on 20, returnable by 27/8/2025. Learned Standing Council, Secondary Education, to obtain instructions with regard to the seniority position of the teachers concerned of the said school.
Obliged. Obliged.
May I please your lordship? Lordship, this is regarding
Just a minute. Give. This also inside the file. Yes, this is regarding.
May I please your lordship? Lordship, this is regarding non-payment of pensionary benefits to the petitioner lordship. At this stage, lordship, notice of motion may go lordship. The petitioner was declared as lordship headmaster of one LP school.
How many petitioner?
One lordship.
Heard Mr.
M. Ahmed.
A. Mohammed, learned counsel for the petitioner. Suppose that by filing this writ petition, the petitioner seeks for a direction to the responding authorities concerned. Provide him pension and other related benefits. What was he? He was a teacher?
Teacher, lordship. Head teacher, lordship.
Since he has superannuated from the post of head teacher on 31/3/2025. Next para issue notice of motion with honorable authorities. Mr. SMT 63, learned secondary standing council, elementary education. Except notice on behalf of respondent numbers
1, 2, 6, 7, 8.
1, 2, 6, 7, and 8. Ms. R.M. Barua, learned semi council, finance department, accepts notice on behalf of respondent number 5. And Mr.
B Sharma for respondent number 4 AG.
B. Sharma, learned semi council, AG Assam, accepts notice on behalf of respondent number 4.
And government is there for final. Pencil.
Ms. Esquire, learned government advocate, appears for respondent number 3. Stop notice is therefore complete. Petitioner to serve requisite copies of the petition to the learned councils appearing today within 2 days. List again after 4 weeks. Stop pendency of the petition shall not be barred for the respondents to process the pension of the petitioner.
May I please announce?
Yes.
Your lordship, we have filed this petition against the order passed by the Director of Secondary Education. It is page 48, rejecting the claim of the petitioner. Prior to that, the order passed by this honorable court, your lordship will find. It starts from page 40. And relevant part is, my lord, at page 42. The findings arrived at by this honorable court on earlier occasions. Para 6, my lord. Page 42.
Yes.
May I read, my lord? The perusal of the aforesaid impugn order, this impugn order was earlier, it was the order of Commissioner, my lord, Education Department. It was set aside by this court. On perusal of aforesaid impugn order would clearly indicate that the authorities did acknowledge the following facts. Opponent of the petitioner as assistant teacher against a maternity leave vacancy, though the impugn order did not reflect the subsequent order issued by the District Elementary Education Officer Sibsagar on 2/4/91. However, in the impugn order, it has been clearly reflected that petitioner's service was extended until further order. Amalgamation of any school where the petitioner was initially appointed with the Serekapar High School on 22/3/2022 has been acknowledged. The impugn order also reflects transfer order issued on 31/3/2003 by the District Elementary Education Officer Sibsagar, transferring the petitioner to Dorika Horiparagat MB School. in the impugned order, the authorities had not acknowledged the fact of keeping in abeyance of the said transfer order by order dated 31/5/2003, which read as follows. Transfer order issued by this office order under memo number so and so dated 31/3/2003 in respect of Srimati Shraddhanjali Chutia, assistant teacher of Cherekapar Gyanodoy ME School, under block elementary education of Sipsagar Khelua, is hereby kept in abeyance with immediate effect and until further order. The authorities, however, gave a finding that the petitioner could not join the said school, which finding, in the opinion of the court, cannot be said to be a correct finding for the reason that transfer order dated 31/3/2003 was stayed by subsequent order dated 31/5/2003. In the impugned order, it has been mentioned that petitioner could not join in the school. However, without referring to the subsequent order dated so and so, keeping in abeyance the transfer order. Then authorities, however, recorded that as per report, this is the important one. Report of headmaster Cherekapar High School, the petitioner received salary up to February 2003, and the petitioner is working continuously without salary. Now, by the impugned order, my lord, your lordship will find the Director of Secondary Education, sitting over the aforesaid order of this honorable court, has arrived at the findings that page 49. Last page at 49. Second paragraph, we may start from second paragraph. Further, the present headmaster in charge of Cherekapar High School in his statement stated that the name of the petitioner Srimati Shraddhanjali Chutia is not found in the record of the Cherekapar High School. Moreover, during the course of hearing, Srimati Shraddhanjali could not submit any supportive document to substantiate her claim regarding rendering her service in the Cherekapar High School after amalgamation of Cherekapar ME School with the State High School. In view of the above facts and finding, it appears that Shraddhanjali Chutia did not render her service as a teacher in so-and-so school after amalgamation of the so-and-so, and accordingly cancelled. Whereas this honorable court has already held that she was working in the school without any salary. So kindly pass the appropriate order. What are the salaries she is entitled, that should be released. Paragraph 10, page 43, my lord. Page 43 of ideal order. What is the direction?
No, where's the finding that you are working?
Yes, my lord. Yeah.
Where is that finding?
Yeah, that is the finding. My lord, para 7.
Please read again.
Yes. Para 7, my lord. This finding referred to para 6-7. That is the last one, my lord. 6-7. In the opinion of the court, is significant for the reason that it indicates that petitioner continued to work in Cherekapar High School as certified by the headmaster of the said school, and that the petitioner continued to work without salary. However, in spite of the aforesaid facts indicating rendering service by the petitioner and lack of any terminating her service, the authorities, however, come to decision with a strict order that after due examination of the reports and records and also taking into consideration the minutes of expert commission, that it appears that there is no merit to allow the claim of the petitioner. So, in the opinion of this court, the aforesaid final decision arrived at by the authorities reflected in the impugned order cannot be said to be correct. Since I am working, so what direction was there? Para 10, accordingly, and for the reason discussed above, this writ petition is allowed. The impugned order is set aside. Respondent authorities are directed to release the salary of the petitioner for service rendered by her in the said Cherekapar High School after making necessary verification. So now, while making verification, the Director of Secondary Education has examined the present headmaster, those who earlier issued certificate, those who are not called for in the hearing.
Okay, will issue notice.
Yes, madam, notice may be issued.
Heard Mr. B. Sinha, learned counsel for the petitioner, who submits that this is the second time the petitioner is before this court. To stop the earlier petition being WPC number 4013 of 2017 was disposed of by order dated 5/12/2019 with a finding that there was substance in the claim of the petitioner for payment of arrears salary. Stop, however, court had given the liberty to the respondents to verify the actual number of days of service rendered by the petitioner and accordingly take a decision. Stop. To the surprise of the petitioner, the respondent authority concerned by order dated 10/8/2024, bracket annexure Roman 14, has come to the decision that the petitioner cannot be allowed any arrear salary as she did not render her service as a teacher in the school after amalgamation of Cherikapar
High School.
Gyanadoy ME School with Cherikapar High School. Stop. Agree if the petition is again before this court. In view of above, issue notice of motion returnable by 4 weeks. Mr. SNP Chisti, learned signing counsel,
Secondary education.
secondary education,
1, 2, 3,
accepts notice on behalf of respondent numbers 1, 2,
3 and 4.
3 and 4.
Here,
Well-
elementary is also there, okay? 4 is the district DO.
You appear for both.
Both.
Okay, Mr. R.M. Barua, learned standing counsel, finance department. Accepts notice on behalf of respondent number 5. Notice is therefore complete. Petitioner to serve requisite copies of the petition to the learned counsel agreeing for the response today within 2 days. List again after 4 weeks.
Lordship, item will be timely. My senior is leg on another book.
May please, your lordship. My lord, it is the 3 writ petitioner has filed to challenge the transfer order, my lord. In the name of rationalization, my lord, a large scale of transfer took place in the district of Sribhumi, my lord. Although at the time of filing, my lord, I could not able to collect all the transfer order, but now I have collected the entire transfer sheet, my lord. Near about 500 teachers has been in the name of rationalization transfer. My lord, kindly see the office memorandum, page 12, my lord. This is the policy regarding rationalization, my lord. Lordship got it?
Yes.
Yes, now, as per this policy, my lord, kindly see page number 15.
Yes.
Serial number Roman 14 and 15 is important for me, my lord. The first attempt will be to transfer, rationalize the teacher with post within the block area to minimize dislocate when within the district. And 15 is if there is non-availability of sufficient teacher in the block area, the district level committee will transfer, rationalize the teacher, shift with post within the district to achieve rationalization as per RTE norms. And another next page 16, my lord, 19, Roman 19. While rationalization is a particular teacher category subject wise, the most junior teacher in the terms of tenure in the service shall be transferred first. Then teacher who have only 3 years of retirement and preferably not to be considered for rationalization. Here in this case, my lord, the first petitioner, the lady, she has been transferred to present place of posting in the month of October 2024. And now she has been transferred from one block to another block. All 3 petitioners has been transferred from one block to another block. Though in the present block where the petitioners are working, in that block, different person has been adjusted. So that means there are availability of vacancy, my lord. In spite of that, this policy has been violated.
What is 21?
My lord,
Serial 21?
serial 20, school education authority is challenged to serve the difficult area like Chor, hilly area. This may not be applicable because I have been transferred, these three petitioners has been transferred from Sribhumi block to the Patharkandi block. First one.
So not applicable. 21 is not applicable.
21 is not applicable.
Okay,
in my-
now where is your transfer order?
Transfer order, my lord, it is at page 19. And entrance transfer sheet, my lord, may I hand it over?
What is that?
This is the, about 500 teachers has been,
Oh, why didn't you annex it? Why are you handing a copy like that?
my lord, it was, I have got subsequently after getting the RTI, my lord.
Then file it.
I'll file, my lord. And main transfer order is at page 19.
This covers all the case.
All, yes, all the case.
The list is not there, but
List is, that is, I subsequently I obtained through RTI, my lord.
Let them file the additional affidavit. Moreover, my lord, that petitioners have has filed, there are three petitioners, my lord.
Yes, I have already,
My lord, different schools, my lord.
already
In
three
fact, they should-
petitioners has been joined, my lord, in the
They should
respect.
have filed it, my lord, separately, my lord. Since it is a.
No, I have paid the court fee, my lord, and I have made a statement also.
Let them, my lord, bring the list on, my lord, by the way of additional affidavit.
My lord, I'll bring the by way of additional affidavit because I have got it but through RTI subsequently, my lord. And I have already joined in my transferred place, my lord. All the three petitioners. Only policy violation I have challenged in this case. Their own policy, my lord, they have violated and transferred from one block to another block. Though there are sufficient number of vacancies available in the present block where the petitioners are working. And another ground, my lord, the lady is only transferred in the year 2024 October, first petitioner.
now have you taken those grounds
Yes, I have
in
taken.
a writ petition?
Yes, I have taken in para 7 can list. All the grounds I have taken, my lord. Para 7 can, page 5.
But why have you filed a common writ petition like that?
Common writ petition, my lord.
Why?
Separate schools, my lord.
Separate school, but the main grievance is policy violation of all the three petitioners.
Maybe.
And I have paid the court fee also with respect to all.
No, maybe paying court fee doesn't mean that you can club everyone together like that.
But I have basically challenged the policy violation. In by a single order, the large scale transfer has been taken place. Page 19 is this order, my lord, by a single order.
Lordship will kindly allow him to file the additional affidavit, my lord. And the other people are not, the private respondent also have to be made a party also, my lord.
No, I have not challenged the entire transfer order.
This is
I
a
have
PI, my
challenged
lord.
with respect to the policy violation from one block to another block. I may be adjusted in the.
This is not a PIL also, my lord.
I may be adjusted in the my block where I have been transferred as per policy, but they have been adjusted in different block.
No, see, that's one thing to say, but the other thing is that you have been transferred to a certain place,
Yes.
vice somebody else, isn't it? That transfer has affected the chain of persons, isn't it? It's not that one person, you go to a place where there's no incumbent.
No, my lord, my contention is that since I have been in the name of rationalization against where I have been transferred, there's from that school, no different teacher was transferred. There was no vice versa.
Okay, no
No
other
vice
teacher.
versa.
Okay. Heard, mister. S.K. Ghosh,
Yes,
learned counsel for the petitioner who submits that by filing this writ petition, the petitioners have challenged their respective transfers which has been made in violation of the guidelines issued by the state government in the Department of School Education. Under the heading, open inverted comma, rationalization of teachers and posts of teachers, close inverted comma, White Office Memorandum dated 5/5/2023, bracket annexure 1. Stop. The learned counsel submits that by transferring and posting the petitioners to a different school, the respondent authorities concerned have violated clause 4.
14, 15.
Just a minute, I've got it. Respondent have violated clause 4 within bracket Roman 14, small, huh? Comma, within bracket Roman 15, small. Comma, within bracket Romans 19. And within bracket Roman 20 of the state policy on transfer. So the learned counsel submits that pursuant to the filing of the writ petition, the petitioners have of late received the entire transfer order and which may be allowed by this court to be filed by way of an additional affidavit. Next para. In view of above, issue notice of motion. Tenable by 4 weeks, Mr. A. Fukan, learned standing counsel.
Elementary education.
Elementary education. Accepts notice on behalf of respondent numbers 1 to 4. Mr. Miss S. Kuwar, learned government advocate, accepts notice on behalf of respondent number 5. And who is number 6?
Private respondent, man.
He said nobody is affected.
His
That's
name
what
may
that's
be,
what I was saying, man.
his name may be struck off, madam. I have no grievance. Because in these 3 applicants, these 3 after getting the entire transfer order, I have found that there was no vice versa, my lord.
Lordship,
So his
there is
name-
confusion in this matter, my lord, because first of all, he's not annexed that particular document which he has sent to, he has given, my lord, to the court, my lord. I have not got a copy of that. So, my lord, he may be, my lord, allowed to file the concerned additional affidavit because there are a lot of
No,
things
I
are
will
issued,
file
my
it.
lord. Now he's saying the private respondent is not a party.
That is coming up. Mr.
Right on.
Fukan, that is coming up. We'll allow him. Insofar as respondent number 6 is concerned, the learned counsel for the petitioner submits that his name, her name, his or her,
Her name.
her name may be struck off since she is not a necessary or proper party in the writ petition. Accordingly, respondent number 6 is struck off as the arrayed respondent. Stop registry to do the needful. Petitioners shall file an additional affidavit incorporating the entire list of transfer which according to them is in violation of the office memorandum dated 5/5/2023. Within
I'll file within 1 week.
within 1 week with copies to the learned counsels for the other side.
Right.
This again after 4 weeks.
Deeply.
Not.
Okay, please, your lordship.
Yes,
Item number 11.
of course, this is 11.
The
What?
petitioner before your lordship was appointed as assistant teacher in Pap Narbharbhak Balika Bit Mandir High School on 5th February 2003. He joined the service. Lordship, he allowed to draw salary against the vacant post by order dated 24 December 2004 by the inspector school, Nalbari, and receiving salary till 31st March 2006. Your lordship, according to government notification dated 10/06/2010, petitioner was appointed in Gobaradal Milan High School. Lordship, kindly persons para 3, page number 5, annexure 3, 4, 5, 6, respectively. Page number 15 to 22, date, notification, advertisement, date of appointment, and joining report in this school of Gobaradal. Your lordship, the said Pab Narbarbhak Balika Mandir High School has been amalgamated by the Gobaradal Milan High School on 15 February 2025. His service has been regularized and posted at Sati Kuchi Janata High School. At present, he is working in the present school, but arrears salary was not received on 19 March 2025. Lordship, petitioner filed the representations before the Director of Secondary Education, Assam, to release the salary of the petitions with effect from 01/04/2006 to 10/08/2010. My humble prayer before your lordship to dispose the representations. Lordship. Here the petitioner was appointed initially on honorary basis, lordship, by the then inspector of schools. Later on, he was appointed on contextual basis, that is to by the member secretary and headmaster. This school is a provincial school, lordship, and the member secretary and headmaster cannot appoint. Yes, they do not have the authority, lordship.
Where's the appointment order?
It is annexure 5, lordship, page 21. Read petition.
Twenty-one.
Initial appointment, that is lordship, annexure 1, page 12.
This is by the inspector of schools.
Lordship.
This was superseded by some other appointment. This was as an assistant teacher of Pub
Number
Number
bhag. Number bhag.
Thereafter, he was appointed in Gobaradal Milan High School. This is a contractual appointment.
Lordship.
What kind of school is this? Gobarandal Milan High School. Is it a provincial high school? Are you still working as on today? Are you still working? Where are you working?
Present in Sati Kuchi Janata High School.
Why? Why you're different school now?
Uh,
Where is your appointment in Janata or transfer? You have changed schools 3 times.
yes.
How is that? How you changing schools? By which order you went to Janata?
The petitioner joined the school after he has appeared exam certificate, government advertisement, annexure 4.
Which school?
In this Sati Kuchi Janata High School.
The next year 4. This is Gobaradal Milan High School. Your writ petition is very cryptic, Miss. Come to your prayer portion also. I don't know what you're asking.
Sir, I'm asking for dispositions of representation.
Where is your representation? You obtain instructions. I'm not issuing notice. Learned counsel for the petitioner submits that being aggrieved for non-payment of salary, the petitioner has come before this court. Stop. She submits that the petitioner has been appointed as assistant. She's working as assistant teacher in Sati Kuchi Janata High School. And she had submitted her representation to the Director of Secondary Education on 19 March 2025. But till date, there is no response. Stopping view of above, Miss, your good name?
NM Sharma.
NM Sharma, Learned Standing Counsel,
Secondary education.
Secondary Education, appearing for all the respondents shall obtain instructions with regard to the status of the representation by the next day. Just the matter again, also. 2 weeks time? Sorry. Petitioner to serve, petitioner shall provide 1 extra copy of the writ petition to Ms. Sharma to enable her to obtain instructions. Give her 1 extra copy. Okay.
May it please your lordship.
Yes.
The petitioner in this case, your lordship, had applied for the post of junior assistant in Margherita College. However, his case was not considered. Your lordship may kindly peruse page 26, the advertisement on 36/2022. May I read, your lordship? In pursuance to the DAC Assam permission letter to so-and-so, applications are invited in the standard form of so-and-so for the post of grade 3 junior assistant along with complete biodata, including contact number and email address and self-attested copies of all testimonials from SLC onwards for filling up the following sanctioned post of grade 3 junior assistant at Margherita College, Margherita. Thereafter, your lordship, I was called for interview, page 27, 23/9/2022 or 14/9/2022, your lordship. I had appeared in the interview, your lordship. Then your lordship may kindly see I was not appointed. Then I had filed an application under the RTI Act, your lordship. Page 29. 7 down below, your lordship. Particulars of information. Had your lordship got it?
Yes.
Particulars of information required, please enclose separate CB required, indicating specific details of information required in the preferred medium, that is inspection, photocopy, etc. One, result of the written test or computer test held on 23/9/2022 at Margherita College for the post of grade 3 junior assistant. Thereafter, your lordship may kindly peruse page 32. 31, I'm sorry, your lordship. 31 is the reply that they've given to me, and 32 is the comparative statement, which was provided with the RTI. Lesson 8/3/2025, your lordship. Your lordship may kindly see page 32. My name appears in the middle. 1, 2, 3, 4, 5, 6. 6 number. Keshav Chandra Gogoi. And the remarks column, your lordship may kindly see. I was selected. The selection committee has selected me, your lordship. In spite of that fact, I was never being appointed, your lordship. I know, your lordship, I do not have a vested right for seeking appointment, but I have a right to be considered for appointment. Your lordship may kindly see. At page 28, they have again advertised the post.
This result is regarding interview only.
Yes, your lordship. I was considered.
What about the written test?
Written and all the tests, your lordship.
It's included.
Yes, your lordship. I am submitting hearing the result of written test and computers for a post of grade 3 junior assistant of this college held on 23/9/2022. So I was selected, your lordship. Thereafter, they ought to have appointed me. Because
Yes.
it's the
How many posts? One post.
only one post, your lordship.
You have scored 69.
Yes, your lordship.
Nearest to you is how much? 67.5.
67.5, your lordship. Ankit Chhetri. Number 2. Serial number 2.
Where's the advertisement?
Advertisement is page 28, your lordship.
28.
28.
What is the stage?
It is just advertisement, your lordship. They have not done anything.
Dated?
Dated 23/11/2024.
From where is saying that?
This is a submission that I made, your lordship, and in my petition. Page 8 of my petition, your lordship.
There's no last date?
No, your lordship.
Annexure 7, there's no last date?
No last date, your lordship.
It says pursuant to the DH's letter dated
Yes.
12/6/23.
Applications are invited for the following post of assistant.
A long time back.
This was the advertisement that was provided to me, your lordship.
The post you applied for was junior assistant.
Junior assistant, your lordship.
Grade 3.
Grade 3. And here also in the advertisement.
And under whose establishment?
Principal and Secretary, Margherita College. Margherita College, your lordship.
Margherita College.
Yes, your lordship.
You are for?
I am for 1 and 2 higher education also.
What do you say?
In earlier, in respect of arrears selection, they found the committee is selected, but there's no way in the committee is recommended to the department and director decision known. There is nothing there.
What is the process after the selection?
Selection, government is recommend one name.
Name has to be recommended and sent to the
director.
Director.
And within 30 days, director has to take decision for that recommendation. This for approval or rejection. You are both.
Margherita is a what college is a provincialized college.
Lot. But on the second earlier, the second advertisement that is in November 24 or so. Now 25 or so. But one thing also, notice issue also, I take instruction, but regarding what happened to earlier selection. Then let us say that second selection on the advertisement is issued on November, month of November. Now is the August last 2005. But taking instruction regarding this law.
May I
notice issue also.
I have specific instructions with respect to this particular advertisement, your lordship. The college authorities have done nothing. The next advertisement, that is 23/11/2024. They've only advertised. They've done nothing, Your Lordship. No process has been taking place. With respect to this is my instructions. Then my learned fellow will be in a better position to give it.
Yes, the
But
notice
this
has
is my
been, the
instruction.
notice to issue, Lordship, Constitutional will come, Lordship. In the meantime, I also take instruction, Lordship. And if any interim is there, then consider that day, Lordship. On my instruction and appearance of the college of social, that will be done, Lordship.
When can you get the instruction?
2 weeks, Lordship.
2 weeks time.
Yes.
Okay.
Till then, Your Lordship, some
Early, on the month of November, Lordship, and he says that nothing will happen. His instruction is nothing will happen. College will do nothing. Then 2 weeks, Lordship, I take instruction, Lordship. Why this happen, Lordship? Maybe that is a recommend there. He rejects, he can be rejected. I don't know, Lordship. That's why we'll file, I will obtain instruction regarding this, Lordship. That will be better, Lordship. Otherwise, create problem, Lordship. Okay, I think that's some anything about it.
Advertisement is issued by the Margarita College. isn't it?
On both the occasions also.
But you're not appearing for Margarita College.
No.
You will not know what is the status.
1 and 2, Lordship. Only
I
1 and
know you are for 1 and 2.
2. Lordship.
So advertisement is issued by the college. They will do the selection process, test and all, interview and all that. Only after that, they will send it to the director.
Yes, sir.
Then only you will know.
Yes.
Now, it seems that there's nothing has happened. That is why they have again once more advertised,
Lordship.
isn't it?
Yes, sir. College is with, that's why I issue notice, Lordship. College official will come and I also take instruction regarding.
Pending instruction, there should be status quo, I think.
Yes, Your Lordship.
Heard Mr. T. Diori, learned counsel for the petitioner, who submits that the petitioner applied for the post of junior assistant in the Margarita College in terms of the advertisement that was published. Most of the petitioner underwent the selection process by appearing in the written test as well as in the interview. But since no results have been declared, the petitioner applied for information by submitting an application through RTI. Stop in response, the petitioner was given the comparative statement of the performance of the candidates who appeared for the selection, wherein he was shown to have been selected, having scored the highest marks amongst the candidates. Stopped. Instead of appointing the petitioner, the respondent authorities concerned have once again advertised the post. On 23/11/2024. Stop being aggrieved, the petition is before this court. Next para, in view of above, issue notice of motion returnable by 3 weeks. Mr. S. Bhuya, Leonard. Standing counsel.
I will say.
Higher education accepts notice on behalf of respondent numbers
1 and 2.
1 and 2. Petitioner to take steps for service on notice upon respondent numbers 4, 5, and 6. 3, 4, and 5, sorry. By registered post with ADD within 3 days. Next para, having regard to the projection made by the petitioner, in the interim, it is here provided that status quo as on today shall be maintained in respect of the post of junior assistant that was advertised on 23/11/2024.
I'm very grateful. In this case, my lord, the petitioners were selected lordship for admission in my lord JNB Jawahar Navodaya Vidyalaya lordship. My lord, thereafter their admissions were also given lordship. Date was given for my lord allotting my lord hostels lordship. My lord, on that day when the petitioners my lord had gone my lord for entering to the hostel in the hostel lordship, they were not allowed lordship. Then submitted application before the my lord deputy commissioner at office at Shillong lordship regional office, and that was also not disposed of lordship. Now that is why before the petitioners before lordship. From the school where they have completed my lord class 5, my lord, earlier since 2012 many students were given admission, my lord. This time my lord the petitioners, all the petitioners were had passed out from my lord Royal Mission Academy. They were not given admission, saying that the school is not recognized. Thereafter, my lord, the dice and pen, my lord, permanent education number was also asked to be submitted, my lord. Then we submitted that, my lord, from the school where we earlier, my lord, had admission lordship. Even then, my lord, we are not allowed to prosecute studies lordship. Now we are in hanging position lordship. We are not in a position to, my lord, study in JNB. Barpeta lordship.
You are seeking admission in
JNB, Jawahar Navodaya Vidyalaya in class 6 lordship.
JNB class 6.
Lordship. Now select list is it at his lordship 27. Our certificates will also signed by the inspector of schools lordship. Yes, 27. This is the number 3, my lord. Petition number was at serial number 3 on merit lordship. My lord, 2 at 41, 3 at 42. My lord, 5 at 58, my lord, page 30. 4, sorry, lord. Yes. 4 at 58 and 5 is at the serial number 71 as page 31. My lord, I have stated in the petition lordship. My lord, the certificates, kindly see the at page 17 lordship annexure 1. This certificate was issued by the Royal Mission Academy and it was duly countersigned by the inspector of schools lordship. My lord, in this way, many students from the same school got admission and they have been prosecuting their studies in JNB Barpeta lordship. But in case of when the petitioners turn came lordship, they were allowed to be participated in the my lord entrance lordship, competitive entrance lordship, and duly selected lordship, then did not allow to prosecute studies lordship.
What is the reason?
It is on saying, my lord, this and that, saying that the PAN number is school is not matched with the name of the school with PAN number, PAN losses, permanent education number, the U dies, and saying that the school from where the petitioners had completed class 5 lordship is not recognized.
What is this annexure 5?
Annexure 5 lordship. This is provisional prior permission of the school, from school where from the petitioners, my lord, completed primary education lordship. Subsequently, the prior permission was granted to that school lordship. This is Royal Mission Academy lordship. As like other students, my lord, well, the performance of that school is very, my lord, high lordship. Each and every year, my lord, the students from that school, my lord, completing class 5 lordship get admission, my lord, in JNB Barbata lordship.
Ms. Devi, you are there.
And for reference for one.
What is your submission on this? One only.
Yes, lordship.
Jawahar Navodaya Vidyalaya. This institution is run by?
This is our Navodaya Vidyalaya Samiti, represented by its chairman, respondent number 2.
What kind of school is this?
Sorry, lordship.
What kind of school is this? Navodaya,
My lord, sponsored by the central government lordship.
sponsored by central government.
Human Research Department Development, my lord, the Department of School Education. My lord, the admit card lordship, policy admit card issued, my lord, at page 22 lordship. To the petition number 1, my lord. This is a Navodaya Vidyalaya Samiti, class 6, Jawahar Navodaya Vidyalaya selection test so and so. A Samiti, my lord, there is a Samiti like, my lord, Kendriya Vidyalaya, and this is sponsored by the central government lord.
All the petitioners are minor lordship. They all are
Represented by their parents lord.
Indian name, the petitioner.
Their fathers, my lord.
See, one thing is that there's a quota for this admission here.
My lord,
There's a quota.
HCST quotas are there. We are not on that ground lordship.
Okay. You're not availing any quota.
My lord, my lord, petitioner number
5.
5 lordship.
SC.
But yes, but ground is not based on the quota lordship. This is different thing.
But
Here,
where's the rejection otherwise?
no order was passed lordship. We submitted application, representation kindly see lordship.
Without signature.
That was, my lord, that was without signature. Copy was, my lord, in the, my lord.
Who has submitted this application?
My lord,
There's no
name
name
is
also.
The name is given lordship in the
Where?
contents lordship. With utmost, my lords, contents kindly see.
No,
With
no.
utmost sincere, with the parents of following.
Just a minute. I have read it. That's why I'm asking you. It's written yours faithfully blank.
My lord,
Yours faithfully who?
original was submitted before the authority lordship. But this is without signature, the copy of the petition. was
Original
extract-
submitted before authority.
extract, my lord.
So what? You should write the name here.
Name, but the names, my lord, Niloy Mozumdar, Selim,
Your name is
Ahmed.
Mr. M.H. Ahmed, isn't it? M.H. Ahmed.
lordship.
Supposing tomorrow you submit on application, you'll put blank like that. To so and so, so and
My
so.
signature is not. This
Yours-
is, my lord, I am submitting.
Yours
lord.
faithfully, and you'll just give like that.
My lord.
Who will accept that kind of application? Who will
My
accept?
My lord, this
Any
was,
reasonable person will accept it.
my original application was signed, my lord. Original application was signed, but the.
Sign is something else.
Yeah.
I'm not talking about signature. I'm talking about the name itself.
My lord, in the contents, it is written, lordship. Kindly see, Niloy Mazumdar, the petition number 5, Selim Ahmed 1, petition number 1.
Okay, don't divert like that. I have no name of petitioner. These people are
Yes,
there.
yes.
But who has written the application? Nobody.
This was not by.
Nobody.
Lordship.
So this application maybe never existed at all. Just to show that you have given some application, you are giving this.
My lord, as per instruction, it was received. Lord,
No date, no name.
My lord, as it was received on my lord 17/6/2025. My date
Anyway,
should be given. In statement, my lord, I have stated loss.
We'll have a notice, that's all. Art Mr. M.H. Ahmed, learned counsel for the petitioner, who submits that the petitioners are minors and are represented by their respective parents. Who stop their grievance is that although they have sought for admission in class 5,
6, Lord.
in class 6, in Jawahar Navodaya Vidyalaya, Barpeta. After completing their class 5th standard in Royal Mission Academy, they have been refused admission in JNV, Barpeta. The learned counsel submits that in the provisional select list, the name of the petitioners appear at serial number 3, 41, 42, 58, and 71 respectively. He further submits that according to the respondent authority concerned, the Royal Mission Academy, from where the petitioners have passed their class 5, is not having a dice code and the recognition of the secondary education, Government of Assam. The learned counsel submits that, in fact, provisional prior permission has been granted to the Royal Mission Academy by the Director of Secondary Education, Assam, on 28/5/2025. Before this, any permission?
No, lordship, application was submitted, lordship, but that was not attended, lordship.
This Royal Mission Academy,
Lordship.
was there any provisional permission
Now, prior to that, no, there.
before May 25? That is why they were rejected. As simple as that.
My lord, prior to our, my lord, town lordship, many students from that school were given admission. Even
Maybe.
this year, lordship, I have given a.
Maybe. But they are now careful. Anyway.
This year also one was given, lordship.
Issue notice of motion returnable by 4 weeks. Miss K. Devi, is it? R. Devi. Learned CGC accept notice on behalf of respondent 1. Petitioner to furnish requisite copies of the petition to her within 2 days. Petitioners to take steps for service of notice upon respondent numbers 2 to 6 by registered post with ADD within 3 working days. Just again after 4 weeks.
In the meantime, I may not be barred to consider the representation motion. It was submitted on 16/7.
What representation? I'm sorry. I don't see any representation at all. There's no name, nothing. Next.
Obligers.
Meet with your lordship. We have filed interlocutory application for implementing the registrar got university as respondent number 7 lordship. New incumbent earlier had my lord vacated his office lordship.
What, Mr.
H. Rahman lordship.
H. Raman, learned counsel for the petitioner, public applicant who submits that by filing this application. The applicant seeks impleadment of Professor Utpal Sharma as respondent number 7 in contempt case C number 597 of 2022. Since he is the new incumbent holding the post of
My lord, register my lord got it recently.
Registrar, Guwahati University. Mr. P.J. Phukan, learned counsel, appears for the
Respondent number 3.
respondent number 3 and has no objection to the prayer. In view of above, application for impleadment as paid for by the applicant is hereby allowed. IA stands disposed of. In the main, right, in view of the order passed today in IAC number 2416 of 2025. Professor Utpal Sharma is impleaded as the respondent number 7. Petitioner shall submit the amended cost title in 2 sets within
1 week lordship.
within 1 week. Whereafter registry shall do the needful. Next para. Issue notice to the newly impleaded respondent number 7. Returnable by 3 weeks. Petitioner to take steps for service of notice on the respondent number 7 by registered post with AD due within 10 days.
Obliged.
Just again after 3 weeks.
My lord, I have an IA, my lord, related to
In this-
matter, my lord.
IA for what?
2505 of 2025.
This one is sort of material.
What is this IA for?
My lord, it's for further clarification in the earlier order, past in review petition.
It's not listed.
Further clarification.
Miller.
Review is disposed of.
Miller, review disposal. Miller, may I take your lordship straight to para 21, the page 18.
Page?
Just to clarify the.
Page.
Page 18, Miller, down below, Miller. Para 21. May I read?
Yes.
That the applicants respectfully beg to state that after submission of the aforesaid detailed communication dated so and so to the Government of Assam, they moved an interlocutory application bearing so and so before this honorable court in this matter, in that review petition. And by an order dated 12/12/2024, this honorable court clarified that the secondary education department as well as the higher education department shall coordinate with each other for giving approval of the appointment of the petitioner as proposed by the Guwahati University in consultation with the finance department. That order has been annexed. Now, para 22. The applicants state that in the meanwhile, it has come to light that there has been glaring illegalities in the engagement of the aforesaid private respondent number 4 on fixed pay as assistant teacher on compassionate ground. And as such, a show-cause notice under memo number so and so dated 2/4/2025 has been issued to the said respondent 4. It is stated that in response to the said show-cause notice dated 2/4/2025, it is after that order, Miller. A reply dated 24/2025 has already been submitted by the aforesaid respondent to the Guwahati University Authority. And the entire matter has also been duly apprised to the last Executive Council's meeting of the Guwahati University. Afterwards, a review committee constituted thereafter has also recorded its observations remarks in this regard. Now, para 23. That the applicant state that in view of these subsequent developments, the orders, it is important, my lord, in view of these subsequent developments, the orders already passed in the above mentioned review petition number so and so, along with ISC number so and so, being executory in nature, shall be impossible to be implemented in the context of the existing laws of the land, as laid down by the Honorable Apex Court and the courts thereunder, including this Honorable Court, as well as the relevant laws, including the eligibility criteria for employment on compassionate ground in Guwahati University, and the Assam government's office memorandum in this regard. My lord, that compassionate appointment, the entire matter revolves around that compassionate appointment of private respondent number 4. That compassionate appointment was totally illegal, and there is glaring, my lord, anomalies and violation of the existing, my lord, laws. My lord, for instance, my lord, she has been appointed after 10 years, my lord, since the demise of her father. Second one, her mother was serving when she was appointed. My lord, these two glaring, my lord, anomalies.
Private respondent number 4.
4, my lord.
In which case?
My lord, this review petition that disposed of, my lord.
Private respondent number 4 in the review case, review petition.
Review petition was moved by Guwahati University. And at that time, that approval aspect was there.
And private respondent number 4 was the petitioner.
Earlier, my lord, in writ petition, she was petitioner.
Out of which the contempt has been.
Yes, sir.
Yes, my lord.
Sir, I may be permitted file objection in this, my lord, ILRC.
Of course, this is the first time, isn't it?
Yes, sir, similar.
Part Mr.
Severe
P.J. Pukul,
illegality.
the standing counsel, Guwahati University, who submits that by filing this application, the applicant seeks clarification of the order passing review.
My prayer, my lord, 21. Page 21.
A review is already there. How do you review a review of court's order? How many times we can review?
My lord, as per Apex Court's order, my lord, second review is not, my lord, maintainable, but clarification part, my lord, I will place those, my lord, judgments, my lord, recent judgments. But clarification part, my lord, since it's an approval, my lord, aspect, my lord, that approval aspect cannot be, my lord, anti-formality. If it is illegal appointment, my lord, then from ab initio, my lord, it is illegal, my lord.
Where is the order which you seek to review for the clarification?
Not review, my lord, clarification, my lord.
Page 31.
Page 56, my lord, 55, 56. Page 56 of my I, my lord.
Meaning part is 51.
51.
Please read the sentence, last part. No, order, clarification of order dated 12/12/2024. Passed in IAC number 3095 of 2024. In connection with review petition number 35 of 2020. Next para. It may be seen that order dated 1/8/2022, passed in review petition number 35 of 2020 was sought to be clarified by IAC number 3095 of 2024, which came to be disposed of by order dated 12/12/2024. Full stop. Now, The applicant has filed yet another application seeking clarification of the order dated 12/12/2024 in IAC number 3095 of 2024. Stop. Next para, be that as it may, let notice be issued, returnable by 3 weeks. Mr.
Be a little bit earlier, 2 weeks.
Returnable by 2 weeks, okay, Mr.
H. Rahman.
H. Rahman, Learned Counsel. Let's notice on behalf of respondent number
4, Lordship. Opposite party number 4, Lordship.
Private respondent 4.
respondent number 4. Well, Mr. SMT Chisti, Learned Standing Counsel, Higher Education Department, accepts notice on behalf of respondent numbers 1, 3, 1 and 3. No,
Milord,
not higher. Secondary? Then number 5.
Respondent 5.
Okay, Mr. Then, right, like Mr. SMT Chisti, Learned Counsel, Standing Counsel, Secondary Education, accept notice on behalf of respondent number 5. Then whom do we record for the higher, I mean, for the higher, yes.
Subrata Bhuya, Milord. Last time he appeared.
Mr. Mr. Miss.
Mr.
Mr. S. Bhuya, Learned Standing Counsel, Higher Department, Higher Education Department, accept notice on behalf of respondent numbers 1 and 3.
1 and 3, Milord.
Finance,
Bring number of finance.
Mr.
This B Gogoi may be recorded on behalf of Mr. B Gogoi, respondent number 2.
B. Gogoi, Learned Standing Counsel, Finance Department, accept notice on behalf of respondent number 2.
Subrata. Hi, middle lesson. Tomorrow number 8. Post of like one.
We have recorded your name, Mr. Bhuya. 1 and 3. Secretary and Director, Higher Education. Notice is therefore complete. Petitioner applicant shall serve requisite copies of the application to the Learned Counsels appearing for the respondents today. List again after 2 weeks on a date to be fixed by the registry. Yes, I've said that. Respondents are at liberty to file their objections in the meantime, if so advised.
Obliged.
Please, your lordship. There are 2 IAs filed by us. IAs are for addition of parties. In IA number 23, in item 61, Milord, it is IA number 2395. And that is for implement. My learned friend is for the petitioners.
Whom do you want to implead?
Well, the applicants at serial 1 to 60, 1 to 15. Sorry, my lord. It is 1 to 60, 1 to 59. Applicants 1 to 59. Lord, that is described in page 2 of the IA.
Application is filed by whom?
Well, they are students in the institute, my lord. And the institute is the petitioner in the case.
Petitioner is the Hamak College of Management Technology.
Yes, and
Correct.
we are students in that institute.
You want to get yourself impleaded?
Yes, yes, ma'am.
Who's for the petitioner?
I am for the petition.
What do you say? to their application?
Then I include that.
How many of them?
Well, 1 to 59.
1 to 59.
I will find out. No, so wait for some relief by the being by the intermediate to this sort of particular distribution. Particularly seeing the irregularities.
Yes.
Later taken. So if they are instance, well, if they are very well further action, they can.
IA for impleading applicants as party. And for appropriate relief. It's 1 to 60, isn't it? Not 1 to 59.
1 to 59.
60 is
1
there?
to 60, yes, yes.
1 to
1 to
60.
60.
So we'll issue notice, let them file objection.
Well, actually, as a matter of fact, my lord, similar petitions are pending before this honorable court where the impleadment has been allowed. In fact, in one of the matters, my lord, it went up to Honorable Supreme Court, my lord, and this was the order passed permitting the applicants therein to get impleaded and seek appropriate relief. Your lordship may kindly see this. Paragraph 3, your lordship will see kindly. So practically, my lord, on that basis, my lord, these applications have been filed. Well, the similar petitions have been ordered by this honorable court. The particular case, my lord, out of which this SLP had arisen, my lord, that your lordship has also may also see, my lord. They are also, my lord, pursuant to this order, my lord, it has been permitted. I think, my lord, I had to for the store. You have to make
Already done.
See, somebody files a writ petition. You want to implead yourself as interveners.
That is permitted, my lord.
And you'll be arrayed as what?
My lord, it can be arrayed as either the intervener, my lord, I can support the cause. Alternatively, my lord, I can also be arrayed as petitioner, which this honorable court has already done in similar cases, my lord.
You're seeking to be arrayed as petitioner in this case.
Yes, it can be, we can be impleaded either as intervener or as a petitioner, as your lordship pleases. My lord, that's why, my lord, I was saying, particularly referring to this order, my lord, the order of the Honorable Supreme Court, my lord. In similar cases, the honorable court has allowed the students to get impleaded as petitioners.
No, see, getting yourself impleaded as a respondent is one thing.
No.
But getting yourself impleaded as the petitioner and thereafter seeking a relief.
No, we can at the minimum, my lord, we can get ourselves impleaded as interveners so as to support the cause in the writ petition. That we can do.
But what relief are you seeking?
Now, my lord, the writ petition has been filed challenging a policy of the government.
Petitioner may seek relief A and B. Now, as interveners, can you go for relief A, B, C, D, E like that?
No, your lordship can at least permit us to support the cause for relief A and B, which the petitioner seeks.
That supporting point is okay.
Yes, that will do, my lord. That will do. We just want to support the cause of the petitioner.
But
in the case before the honorable court now, and the matter which, my lord,
hitching a ride on somebody's bus and getting relief.
No, that is permitted by the Honorable Supreme Court because of the fact, my lord, ultimately it is the interest of the students. The question of granting the recognition and all
Ultimately, the interest of the students are involved. That is
No,
why, my lord, it was
No,
allowed.
permission means court, apex court has said that you may file, seek whatever relief. It didn't say that you go there and you should be given the relief.
No, my lord, that's why I am saying.
That
Lord, at least-
finality has to be taken a call by the court.
Yes.
Concerned.
Yes,
isn't it?
yes. So,
Court is-
so at this stage, your lordship can at least allow us to be implemented as interveners so that we can support the cause. And in that respect, my lord, no prejudice would be caused to either of the parties.
Where is the case wherein you say that similar matters we have already been impleaded?
My lord, that
Is it connected to this case?
No, but it is of the similar nature. They are also, my lord, one policy of the education department, I mean, the state university has been in challenge. And it is in consideration, it is this order, my lord, out of which, this writ petition, my lord, out of which the matter went up to the Honorable Supreme Court. And there, my lord, one of the writ petition is also tagged. And in that batch, my lord, we are also, I mean, the writ petitioner in this case is also one of the parties. Lordship will find the name of the writ petitioner in page 12.
Come to your prayer portion. What are you seeking here?
The prayer, your lordship will find at page 24.
Admit petition, call records, allow applicants as party in so and so. Grant amend the cost title accordingly, then
Well, that
allow temporary
these are actually subsequent prayers. Basically, my lord,
final
it has to be-
affiliation. No, can you make all these prayers?
Basically, my lord, it has to be a prayer for impleading the parties.
It is not there. You will be impleaded as interveners, not as petitioners.
Yes, your lordship may kindly pass that order.
But you have not made that prayer.
That has not been specifically made, but then, but your lordship can always pass appropriate orders, my lord. Otherwise, otherwise, my lord, there will be separate IAS to change this course.
You have no objection. Mr. Gogoi has some objection.
He.
IA
395, yes.
2395.
2395.
Yes. Well, here.
My lord, it is, my lord, he is right, my lord, in a sense that the prayer is little
No,
bit
what we will see, my lord,
topsy-turvy
for a
here.
moment, my lord, so what is page 24, para 2.
Page 24, para 2 no hoga, to para 20 hoga.
24 is prayer portion. Which para 2?
Well,
24 can I
actually,
cover?
no, I copy has been served to us, my lord. Directly served to the petitioner and they are moving it, my lord. No copy.
No,
has
no,
been served.
my lord, that education department, it has been served.
Huh?
Education
Yeah,
department
for
is
the
service.
University, my lord.
There are two, pagination.
Lordship will see page 14 for a moment, just one line.
Page?
Page 14, para 2, the part of para.
Oh, page 14. 14, my lord.
Also we see here. Yes. The 7th line. Accordingly, the counseling was conducted by the college and after counseling, the applications are being found eligible in BTech, MBA courses in the above college. The applicants number 1 to 35 were taken admission in BTech. Well, so far as the present petition is concerned, is regarding the nursing education.
No.
No.
It's regarding, my lord, present petition is regarding the college lordship for affiliation of the college under ASTU lordship or.
Well, I file my objection. Reason objection. A copy may be served to me, I will file my objection. I will pay for
Copy
the.
has been served, but I think.
No.
No,
It has not been served.
copy, huh?
If they can show from the record that it has been served upon me, that's a different thing. No, it has not been served.
Copy has been served.
At least today, my lord, within 2 weeks, I will find my objection.
Mr. Gogoi, you're appearing for which department?
The university, man.
Which university?
Assam Science and Technology University.
Assam Science and
This is the
Technology.
main respondent here, man.
Oh.
And the other part, lordship, in the main read petition, he is to file his affidavit, lordship, on the petition, lordship. We have also filed an IA for interim prayer, lordship. That a part of impleading party, lordship. In the main read petition, lordship, my learned friend have to supposed to file it is.
But today the IA is taken up, man, it may be taken up.
Lordship. Lordship, because the last 2 occasions, lordship, my learned friend has taken time to file affidavit, lordship. Let item 61, lordship, and 62 also. Apart from his impleading petition, lordship, my learned friend to support the ASTU is supposed to file their affidavit, lordship.
Well,
Objection in the main read petition, lordship.
What about 62?
62 also same, lordship. Same, it is an architect, lordship college. Same.
It's a different college, my lord, but the thing is same, and the issue is same. Course is different, but the issue is same.
Issue is same, lordship.
You are there also, Mr. Gogoi there?
Yes, lordship.
well, yes,
And
yes.
that IA is also the same thing for impleadment.
Yes, same thing. My submission is that, my lord, at least your lordship can add us as interveners.
But that I have objection. Lord.
Adding us as intervener, my lord, primarily the matter is between the writ petitioner and us. A co-respondent cannot have any objection as far as the impleadment is concerned.
As a petitioner, my lord, I have objection. And
Impleadment,
secondly,
my lord, is a matter between the writ petitioner because it is his writ petition. His writ petition, and I want to get impleaded as an intervener in that case. A co-respondent cannot file any objection to that.
Lordship will see, my lord, page 47 of the writ petition. If the Lordship is taking up the writ petition. Just I want to point out, my lord, I would say, my lord, this
No.
particular writ petition is not maintainable in the present forum. It will be before a division bench. They are challenging a particular provision of the act of the university. That is a statute, my lord. It has been passed
In the
by
writ
cabinet.
petition.
Yes,
In the,
in this writ petition. But 42B, Lordship will see, my lord.
it is a lordship, it is a notification, lordship. It is not a.
It is
What
a
I will
gazetted
challenge-
one, my lord.
In any case, my lord, the maintainability of the writ petition is not for consideration today.
File my objection.
My
in the-
submission is only on the IA.
Then, my lord, we should.
See, IA, furnish him a copy, let him file his objection. Meantime, in the writ petition also, you file your objection and counter whatever you want to file.
Lordship,
Will-
let the matter may be fixed up within 1 o'clock because
Yes.
last occasion also we have a little bit urgency, lordship.
Urgency is there.
Lordship, regarding only one clause that is the state government objection is necessary. No objection certificate is to be required. We have paid all the fees and everything.
Okay,
lordship.
please write. The applicants in IA 2395/2025 and IAC number 2597 of 2025 to serve a copy of the application to Mr. B. Gogoi, Lanet Standing Council.
Ask to-
What is this? Assam Science and Technology University. Who shall thereafter file objection within a period of 1 week if so advised. Stop. In the main writ petition,
In the main read petition, lordship,
the respondents, including the Assam Science and Technology University, to file their counter affidavit as expeditious as possible
within 1 week, lordship, because.
Yes,
it's
I will
the
file it in 1 week. I did not.
Lordship, it may be.
and
fixed-
preferably within a period of 1 week from
Well,
today,
It may be fixed on.
since urgency is expressed. To stop next para in view of above, list these matters again after a week on a date to be fixed by the registry.
Now, can it be on 21st of this month?
Lordship.
It will be after a week.
No, let them fix the date, registry.
it-
After 1 week, it'll come up.
Well, I will file now.
So counter affidavit and objection, whatever you have to file, serve him a copy.
Yes.
So this order will be common for item 61 and 62, okay?
May I please, Your Lordship?
Yes.
My lord, this matter pertains to admission into first year MBBS BDS course. The petitioners are aspirants, my lord. The NTA has issued a public notice by dated 7th of February 2025 as per provision prescribed under section 14 of the National Medical Commission Act, my lord. That notification I have annexed, my lord, at page 21 of my writ petition. As per the notification, the date of registration, last date of registration is given as 7th of March. It's the first row of the tabular form, my lord. 7th February 2025 to 7th of March 2025.
Just a minute, Mr. Saikia.
Yes, Your Lordship.
Just a minute. Yes.
My lord, after issuing that notice, the petitioners applied for, my lord, and accordingly, they have appeared in the examination, my lord. During the midway, my lord, on 9th of April 2025, the government of Assam has amended the existing rule, that is, my lord, the medical colleges and dental colleges of Assam, regulation of admission into first year MBBS or BDS courses, amendment rules 2025, which I have annexed at page 33 as annexure 7, my lord.
Yes.
My lord, by this amendment, Schedule 3 to the rule, namely the medical colleges and dental colleges of Assam, regulation of admission into first year MBBS BDS courses, rules 2017, my lord, has been substituted, whereby, my lord, a provision for reservation, 5% reservation for government candidates who have studied since class 7 to 2012 has been provided, has dropped, my lord, which was brought into the purview of the rule by the earlier amendment, my lord, dated 13th of March 2024, which is existed and prevailing at the time of registration for NEET, that is National Eligibility Cum Entrance Test, my lord, which have been conducted by the NTA, issuing notice on 7th of February 2025, my lord. My lord, I like to draw attention to the page number 47 of writ petition, my lord, the provision for reservation. It is clause 5.1 R. 11 portion is at page 47. R is there, my lord.
Yes.
Here, quota for candidate who have passed from Assam State Government School, College, provincialized colleges. 5% of MBBS seats reserved for those students who studied from class 7 to 10 in government school under SEBA and class 11 and 12 in state government school, college, provincialized colleges of Assam under ASSEC. The reservation is not a separate reservation over and above the reservations if the candidate belongs to any of the following categories: vice, ST, SC, OBC, MOBC, NCL, EWS, or general category, he or she shall be adjusted against the category to which he or she belongs. Means it is horizontal reservation, my lord. It's also provided for BDS courses, my lord. It's in the next column, my lord. My lord, thereafter, on 1st of July 2025, my lord, Director of Medical Education Assam has issued an education notice whereby application has been invited from the special categories, but in this notification, the provision for 5% reservation for candidates who have studied in government school has not been mentioned, my lord. It is at page 50, annexure 9. Thereafter, my lord, on 4th of July 2025, another education notice has been issued by the DME Assam, wherein it is specifically mentioned that, my lord, I am reading the paragraph 2 at page 51, my lord, annexure 10. I am reading second paragraph. All the admission into MBBS BDS courses in the government medical and dental colleges of Assam will be as per the Medical College and Dental Colleges of Assam Regulation of Admission into First Year MBBS BDS Courses Rules 2017, amended up to 25. My grievance is that, my lord, this amendment made by notification dated 9th of April 2025 cannot be applicable to the admission process which has been initiated by notification issued by the NTA on 7th of February 2025, my lord, because this amendment is midway amendment, my lord.
So question is,
my lord,
question is the link between the NTA
yes,
and
my lord.
and the
Yes, my lord.
and the
Counseling.
counseling
Yes, my lord.
notification issued by the medical education.
Yes, your lordship. My lord, the respondent has filed affidavit in response to my petitions, my lord, and wherein the information bulletin has been annexed herewith as per the provision, my lord, 6.1.1. It is page 110, that is in the affidavit in opposition filed by the respondent.
Information bulletin is issued by whom?
My lord, NTA.
NTA.
Yes, your lordship.
This is an agency
Agency, my lord.
which conducts the examination.
Not the examination. But power exercise and given under section 14 of the National Medical Commission Act 2019. I have filed reply to this affidavit, my lord, wherein I have annexed that act also, my lord.
Okay.
The provision 6.1.1 of the information bulletin stated admission to all seats of undergraduate medical dental courses will be done through NEET 2025. Wherefrom it is clear, my lord, for all medical institutions, the admission process start by this NEET, and NEET is conducted by the NTA. The counseling is second part, not the beginning, my lord.
Yes.
My lord, para 6.1.2, it has been mentioned the counseling for admission to the states under the control of state government, UT administrations, state universities, institutions shall be conducted by the designated authorities of the state government as per the notification issued separately by the authorities concerned. My lord, it is second part. First part, the entrance test has been conducted by the NTA, that is NEET. So, my lord, the admission process has started from the notification issued for NEET. My lord, during counseling, the authorities, regulating authorities have to examine the documents which have been submitted to the NTA at the time of registration for a NEET. That is also mentioned in para 6.1.4 of the information bulletin. My lord, in information bulletin para 6.1.6 at page 111. Here it is stated, an all India merit list of the qualified candidates shall be prepared based on all India rank in the merit list of the NEET UG 2025, and candidates shall be admitted to undergraduate medical courses from the said list only. Here it is, said list only has been mentioned, my lord. With existing reservation policy, NTA will only provide all India rank to candidates, while admitting authorities will invite applications for counseling, and a merit list shall be drawn based on all India rank by the admitting authorities. Admission to the undergraduate medical courses within the respective categories shall be based solely on all India rank as per merit list of NEET. So, my lord, it is clear, my lord, that NEET is the beginning, NEET is the entrance test for admission into first year MBBS course into all institutions, which is also mentioned in section 14 itself, my lord, of the National Medical Commission Act 2019. My lord, next page at page 112, my lord. Para 6.1.6 clause A, subclause A, Roman 1. Here it's mentioned, admission under state quota seats shall be subject to reservation policy and the eligibility criteria prevailing in the state. This information bulletin has been issued along with the notice, my lord, as such prevailing in the state. That 5% reservation policy was at that time it was prevailing, my lord, and as existing. So it should be applied for this session, my lord. My lord, in subclause 2, the reservation of the seats in medical colleges for respective categories shall be as per applicable laws prevailing in the state, union territories concerned. So, my lord, both cannot be said that both are separate and independent. Counseling and entrance test are part of admission process, and entrance test is the beginning and counseling is subsequent to the entrance examination, and on the basis of the result declared by the authority upon the entrance test.
Yes.
My lord, I like to draw attention to at page 20, my lord. Second paragraph of clause 6.4, my lord, second paragraph. Reservation in state quota seats. Universities, institutions.
Page 11.
Page 120.
120.
Yes, your lordship.
6.4.
6.4.
Yes,
Second paragraph. Reservation in state quota seats, universities, institutions, private medical colleges under state governments in case of seat filled by the state medical college, university, institutions, private medical colleges under state quota seats, the reservation policy of the concerned state government shall apply. So, my lord, state cannot say the quota mentioned in the NEET is only the reservation provision for providing seats, my lord. Now, my lord, I come back to page number 94 of that information bulletin, my lord.
Yes.
Para 2.2.1. The NEET UG 2025 is going to be conducted by NTA as per the schedule given in the information at a glance for admission to MBBS, BDS, BAMS, BSMS, BUMS, and BHMS courses as per the relevant norms, guidelines, regulations notified by the concerned regulatory bodies of the Indian system of medicine in all medical institutions governed under this act. So, my lord, the state cannot say admission into the medical institutions under the control of state is different from the NEET. Para 2.3.1. The responsibility of NTA is limited to inviting online applications, the conduct of the entrance test, declaration of the result, and providing all India rank to the Director General of Health Services, Ministry of Health and Family Welfare, Government of India. Then, my lord, 2.3.2, the information contained in this information bulletin relating to the pattern of exam syllabus eligibility criteria for appearing in NEET UG, the quota of seats, reservation, PWD, admission norms, procedure pertaining to the concerned courses are as per the norms set out by the respective regulatory bodies, my lord. So, my lord, the state authority cannot say that we are separate, we are different, we are no way connected with NEET, my lord. My lord, I have already submitted before your lordship one judgment passed by our High Court, my lord, in 2017. My lord, here, entire case is similar to the case in hand, my lord. And in this judgment, the law point has been decided as, my lord, at para 25. The Supreme Court in Doli Sanda versus Chairman JWE reported in 2005-9 SCC 779 had declared that while applying for any course of study, the person must possess the eligibility qualification on the last date for application. In the case in hand, my lord, the last date of application registration was on 3rd of March, 7th of March 2025, my lord. As such, the law prevailing at that time is the law for this session, wherein the 5% reservation policy was there, my lord. Subsequently, my lord, in the month of April, right dated 9th of April 2025, that reservation policy was dropped, removed. That was midway. That period for application for this year's admission was so and so, my lord. In this case, my lord, that is 7th of March 2025. My lord, on last occasion, I have forwarded a copy, my lord, of judgment of the Apex Court, my lord, Shankar K. Mandal and others, my lord. I am relying upon para 5 of this judgment, my lord. My lord, relevant portion is at page 4, my lord, wherein 3 guidelines has been framed, my lord.
What is the name of the party?
In this case, my lord, Shankar K. Mandal and others
Mhm.
versus State of Bihar and others. It was reported in SCC, my lord, 2003 9 SCC 519. My lord, I am reading the whole paragraph 5. Pursuant to the directions contained in the earlier judgment of the High Court as affirmed by this court, a fresh exercise was undertaken. Since the present appellants were not selected, writ petitions were filed before the High Court. In the writ petition, which was filed by 55 persons and disposed of by division bench, the conclusions were essentially as follows. Some of the writ petitioners were over age at the time of their initial appointment and their cases were therefore wholly covered by the directions given by the High Court and they were not entitled to relaxation of age. Second, so far as writ petitions number 6, 26, 30 and 55 are concerned, the stand was that they had not crossed the age limit at the time of making the applications for appointment and therefore were within the age limit at the time of initial appointment and were therefore entitled to relaxation of age in terms of the judgment passed by High Court earlier and affirmed by this court. This plea was turned down on the ground that what was relevant for consideration related to the age at the time of initial appointment and not making of application. Third, as regards writ petitioner number 24, he was under age at the time of appointment. He was permitted to file a representation before the Director of Primary Education and High Court ordered that his case would be considered afresh. Fourthly, in respect of writ petitions number 9 and 17, it was noted that they were refused absorption on the ground that they had not made any application in response to advertisement issued pursuant to the order passed by this court. Since no material was placed to substantiate this stand and no reasons had been communicated for non-absorption, direction was given to consider representation, if any, by them within 1 month from the date of judgment. The said judgment is under silence in criminal appeal, civil appeal number 916, 1999. Appellants had taken the stand that in terms of the court, a judgment, a person who was not over age on the date of initial appointment was to be considered. Though it was considered before the High Court that they were over age at the time of initial appointment, much would turn as to what is the date of initial appointment. The High Court had not considered as to what was the applicable rule so far as the eligibility regarding age is concerned. Learned counsel appearing for the respondent state, however, submitted that having made a concession before the High Court that they were over age on the date of appointment, it is not open to the appellants to take a different stand. The crucial question is whether appellants were over age on the date of their initial appointment. It is true that there was concession before the High Court that they were over age on the date of initial appointment, but there was no concession that they were over age at the time of making the application. There was no definite material before the High Court as to what was the eligibility criteria. So far as age is concerned, no definite material was placed before the High Court. And also before the court to give a definite finding on that aspect. What happens when a cutoff date is fixed for fulfilling the prescribed qualification relating to age by a candidate for appointment and the effect of any non-prescription has been considered by this court in several cases. The principle put out, called out from the decisions of this court, Ashok Kumar Sharma and others versus Chandrasekhar and others, 1997 for SCC 18. Bhupinder Pal Singh versus State of Punjab, 2005, SCC 262, and Jasbir Rani and other State of Punjab and another are as follows. The cutoff date by reference to which the eligibility requirement must be satisfied by the candidate seeking at a public employment is the date appointed by the relevant service rules. If there is no cutoff date appointed by the rule, then such date shall be as appointed for the purpose of the advertisement calling for applications. If there is no such date appointed, then the eligibility criteria shall be applicable by reference to the last date appointed by which the application were to be received by the competent authority. Here, my lord, in the instant case, my lord, there is no date has been mentioned on what date considered the rules which is applicable, my lord. So, my lord, the third guideline have to be applicable, my lord, when it is clearly stated. If there is no such date appointed, then the eligibility criteria shall be applicable by reference to the last date appointed by the applications were to be received by the competent authority, my lord. Now, my lord, I like to draw attention to the very rule, my lord. That is annexed. I have annexed with my affidavit in reply, my lord. At page 118. My lord, section 2 definitions.
Which?
Close. My lord, at page 18, section 2 definitions.
Page 18.
118. Annexer R2. My lord, affidavit filed today, my lord. Affidavit in reply filed today.
This is the one. But it starts with page number 181.
Yes, your lordship. 181.
You were saying page 118.
Yes, your lordship.
What do you mean, yes?
Oh, sorry, my lord. 218. 218.
Yes, 218. What is this?
Notification dated 1st of July 2017, my lord.
2017 rules.
Yes, your lordship.
This has been amended.
Yes, my lord, but the definitions has not been amended.
This was amended in 23, then 25.
24 also.
Or 24, 23, 24, 25.
Yes, my lord.
Now you want to show me the definition.
Yes, your lordship.
Section 2.
Section 2. My lord, close 24. State merit list.
Yes.
Means the list of state quota candidates in order of merit for the state quota seats prepared by the examination conducting authority. It means the state list also as per NTA, as per the result of NEET. My lord, next 25 state quota candidates means those candidates appearing the NEET and applying for the state quota seats. So, my lord, the rule itself, my lord, select list defined from the definition of the state merit list, my lord. It can be revealed that the NTA conducted the NEET, and the merit list of the NEET is the select list of the state merit list for admission into MBBS BDS courses, my lord. As such, my lord, there is no difference between NEET and counseling. Differences they are, my lord, that is stages. First stage is the NEET, the entrance test. And second stage is the counseling, which is conducted by the state authority. And the NEET is conducted by the NTA as per provision of section 14 of the National Medical Council Act 2019. As such, the admission process for this session 2025-26 is starts from 7th of February 2025 from the date when the NTA issued the public notice inviting application for registration for NEET.
See, let us try to understand the stages.
Yes,
First is the entrance test.
yes, your lordship.
Now, in the entrance test, those who qualify, as per the state quota, they're called for counseling.
They have prepared prepared merit list for state quota seats and call for counseling.
They call for counseling.
Counseling.
You have not been called for counseling. In your
No,
case,
no, my lord. In my case, my grievance is that, my lord, as per the education notice issued by the DME, Director of Medical Education, high dated 4th of July 2025, it mentioned that the rule amended up to 2025 have to be applied for admission into the session.
okay, that part is okay, but counseling will be given irrespective of whether you are selected or not, ultimately.
My lord, we make a call for, my lord, for counseling.
You may be called, but ultimately you may not be selected.
No, my lord, till now result has not been declared, my lord.
Which result? Which result?
After counseling, my lord.
There's a separate result again after counseling.
After counseling, obviously, their result, my lord.
So those who clear the entrance test, whoever clears the entrance test, they're called for counseling. And in this case, there are 3 stages counseling.
My lord, actually, the state authority have to conduct the counseling and the subsequent admission processes, my lord. But before that, the amendment has come, whereby our expectation that the 5% reservation has been removed. Our grievance is that at the time of application for NEET, the reservation policy was there. 5% reservation for candidates who have studied in government.
That part is okay. That part I have understood.
Yes, your lordship.
Reservation is there. Since I have been studying in the government school, I should get that 5% reservation. I'll have a better chance.
Yes.
My question was something else. Entrance test is there.
Yes, your lordship.
And there are people who are selected.
Yes, my lord.
And those who are selected are called for counseling. Or whoever participates in the entrance test are called for counseling.
Yes, your lordship.
How is it done?
My lord, the state authority has issued the education notice, my lord, whereby the list has been published. The list
After the entrance test.
as per solely based on the NEET result, my lord.
As per the NEET.
Yes, your lordship. But first, who have applied for admission into the state quota seats. For each state,
as per the results of the NEET.
Yes, your lordship.
As per the results of the NEET.
NEET, which has been mentioned in the information bulletin 6.1.1, that is solely based on the All India rank.
No, at what stage will you get that advantage of that reservation?
My lord, reservation comes at the stage of counseling, because after counseling, the result will be declared and allotting seats for admission, my lord. the seat matrix has been published, my lord, wherein for all the categories has mentioned the seat, total seat numbers, my lord. Out of that categories, my lord, 5% should be given to the candidate who have studied in government schools.
Can I just ask Mr.
ma'am.
Gogoi to explain the stage?
Well, here, well, so far as the NEET is concerned,
Ah.
NEET exam.
Need exam is there?
So, my lord, may I explain you, my lord? So far as the, my lord, NEET exam is concerned,
Ah.
it's conducted for the entire country, my lord.
Entire country.
Yes.
Correct.
One examination from every state candidates will participate.
Hmm.
They have got two options, my lord. They can apply for the All India quota or the state quota.
State quota.
If it is All India quota, they will be admitted anywhere across the country. That's for their merit position.
As per the merit position.
That is a separate eligibility criteria, and that is conducted by the central government or the Ministry of Health and Family Welfare. It is there in the particular bulletin.
And as per state quota?
Yes. Now, my lord, out of the 100% seat of the state, my lord, 15% will go to the 15% will go to the All India quota. Every state will have to contribute 15% for the All India quota. 85% remains for the state. Now that is called the state quota.
Okay.
State quota seats. Now, my lord, after the NEET result is declared, it will be a common, my lord, result seat for the entire country. Now, considering the preference made by the candidate, supposedly certain candidates apply for the state of Assam, their merit list will be segregated from the All India list, and it will be forwarded to the counseling authority, that is Director of Medical Education Assam, for conducting the counseling for filling up the seat of the state quota seats. All India level seats will be conducted by the central authority only, the 15% from every state.
Question is, who are called for counseling?
My lord, counseling, my lord,
Those who appear on the merit
yes.
list.
That's why I'm saying, moment we get the list from the central government
Hmm.
for the state quota seats, students who have applied for the state quota seats, then, my lord, a category wise list is prepared, merit list, say ST, SC and all. And accordingly, dates are given, say for the first round of counseling for unreserved category on a specific date.
Hmm.
And say, supposingly, my lord, we have say 100 seats for unreserved category.
Hmm.
Considering that, we may call say 300 candidates, roll numbers will be given as per the merit list. So that they can at least be present in the counseling. It's an online counseling. So when the 100 seats are filled up, then leftover category starts, like the unreserved and all that. Or reserved category starts after the unreserved category is filled up on merit manner. Left out merit goes for the reserved category. And nothing called merit cutoff.
No, initially it's the general.
Yes, that's why unreserved.
Unreserved.
Will be filled up. And whatever horizontal reservations that there, my lord, in the unreserved category, that will also be filled up, like my lord, economically weaker section will come with the quota.
No, to what extent will that go? Unreserved category.
That will depend upon the merit position, my lord. How much the candidates have scored, my lord. There may be in a particular rank, my lord. There will be 2-3 candidates also. You can't say, my lord. According to the results, my lord, whatever is there from the top, we will start filling up. Say 106. 1 to 100 we will try. We'll give an option. Supposingly they don't want to, my lord, join. Then, my lord, then merit will go down. Otherwise, my lord, 1 to 100 will automatically filled up, my lord. Irrespective of whatever reservation.
Then what will remain for the reserve category?
After say 100 rank, my lord, say 101 rank, then my lord, reservation will come. Say the 101 rank holder is a, my lord, ST Hills or STP.
That will be to what extent?
That we can't say, but it will depend upon every year, my lord. Because merit position will it varies from every year, my lord.
No, that will depend on the vacancy.
Yes. Not only vacancy, my lord, merit position will say this time, my lord, maybe the merit position of the first candidate is so and so percentage. This percentile, I suppose. So here it will go down, it may go up. There's a different thing, my lord. Whoever names are there, my lord, in the merit list, they will be called. And on merit, it will be filled up. So you cannot say that this much is the percentage that will be, my lord, necessary for getting a particular seat in the state of Assam under this category or the unreserved category. That will depend upon each year, my lord, whatever is the rank, how much, my lord, they have scored. There is a separate, my lord, altogether. Here the issue is this, my lord. So far as the NEET exam is concerned, their contention is that, my lord, the NEET exam is the starting of the entire process till the admission. Our contention is that, my lord, these are two separate processes. One is, my lord, NEET, which is conducted by the central agency. There is a national testing agency, which came into force from 2019, my lord. It has been constituted by the central government. I will point out that, my lord. From 19, they are holding it. Otherwise, in 2017, it is a CBSC who conducted that 2017 examination, NEET examination. And these are at that point of time, it is, my lord, MCI was there. Now MCI has been abolished in 2020. So now it is, my lord, National Medical Commission. instead of MCI, which the main apex regulatory authority.
National Medical Commission.
Commission, my lord. So may I, my lord, play this particular bulletin, everything will be clear, my lord. From beginning
Yes.
at-
No, we'll complete with the petitioner's
Yes.
counsel first, then we'll come to you. I wanted some clarification, that's
Yes.
what. So the percentage is,
It varies, my lord.
it varies, but percentage is fixed. 15% is
Yes,
surrendered for this,
85
for all India,
Yes.
national. 85 retained by the state.
Yes. Out of
Out of
my
total
lord,
seats.
as per the percentage of category, say unreserved categories, such and such seats, for reserved categories, ST is in 1%. As per the statute, it will be done. And that varies from each state.
Hmm.
Because my lord, there are certain criteria fixed for being eligible for the state quota seats under the domicile category also.
So now what they're pressing on is,
No, just because a particular candidate is eligible to appear in it, it doesn't mean that he will also be eligible to, my lord, have a seat under the state quota seats. That's why, my lord, repeatedly this bulletin has stated that, my lord, counseling will be held by separate notification issued by the designated counseling authority as per their available rules. Whatever rule is here, my lord, in the state of Assam, that will be followed for filling up the state quota seats. For West Bengal, it will be different, my lord.
that is one aspect. The other thing is that supposing what they contend
My lord.
is that they should get the reservation. And that 2025 cannot take away their right.
My lord,
The
that
process
will be-
started
Yes.
at an earlier
That-
point of time.
it is private.
Then they will get the advantage of that 5%.
If my lord lordship holds that, my lord, this particular 2025 amendment cannot be applied for the counseling, my lord, 2025, in that case, my lord, 24 rules will prevail. That where, my lord, they will given the particular category for reservation
Preference.
1 year only, 24. There also it is mentioned that it will be only for the session 2024 in the rule itself.
What do you call,
My lord,
that particular reservation?
yes, my lord, R, 5.1 R.
No, where does it say it's only for 1 year?
No, I'm not saying that, my lord. In 2025, it has been amended now.
No, correct.
Yes.
Now, without amendment, what
Yes.
benefit will they get?
My lord, that they will get that, my
The
lord,
5%
In
consideration.
addition to, my lord, he is a, my lord, otherwise, my lord, someone is STP as well as EWS. So he will get a third option, my lord, STP, again, my lord, EWS quota. and
Supposing
my lord,
STP,
5%.
supposing STP, amongst the STP,
He will be,
if he belongs to that category, he will get one more.
he will get
advantage.
Options, my lord,
Ah.
even down below also in rank, my lord, he may get the option because, my lord, supposedly pride in, my lord, economically weaker section, again, that is a horizontal reservation. He fails, then, my lord, for the government school, that 5%, he may again try. He will get a better option. That's a whole minor issue.
Okay. Yes. You wind up your argument.
My lord, in this regard, my lord, I also like to draw your attention, my lord, to one notification, my lord. Education notice, that is at page 50 of my petition, my lord. This notice issued, my lord, inviting application for special quota seats, my lord. But this 5% also special quota, but it has not been mentioned here, my lord. From this stage, my lord, the reservation benefit starts, my lord, regarding special quota.
Page 50.
50.
Who has issued this? This is by the Director of Medical.
Medical Education.
What does it say?
My lord, it has invited application. Applications are invited from candidates seeking admission into first year MBBS BDS courses in the government medical and dental colleges of Assam, session 25 under special quota.
Special quota.
Special quota.
You are not included.
But
that particular quota is not included, isn't it?
yes, here, my lord, my is also a special quota, my lord.
That clause R is not there.
Yes, my lord.
Clause R reservation is not there.
Abolished later on, my lord, by notification dated 9th of April. My lord, because of this, my lord, for during counseling, my lord, for 5% quota, the counseling authority will not consider, my lord. 5% quota, if application invited and the sum of we have applied, then the counseling authority must consider the 5% reservation, my lord. My lord.
So the problem started from this 1st of July,
1st of July, my lord.
then 4th of July.
Then 4th of July.
Thereafter, that amendment.
The amendment earlier, my lord, amendment was made on 9th of April 2025.
I mean, this is another hurdle.
Yes, my lord.
That was in terms of the amendment only.
Yes, your lordship.
So earlier it was there, but by the amendment, there has been done away with.
Yes, your lordship.
And your case is that the process started
Yes. process
earlier,
started-
earlier before the amendment.
Amendment.
So
So
it
that
should not
amendment-
apply to you.
Yes, your lordship.
Hmm.
My lord, in addition to that, my lord, as my learned hand stated, and the affidavit also stated that counseling is separate from the need.
Hmm.
My lord, in this regard, I like to come back again to the information bulletin, my lord, at page 122.
Yes, 122.
Clause 6.6, instructions for counseling by MCC for MBBS and BDS admission. My lord, state authority is not independent to do, my lord. It is also as per instruction of the medical counseling committee. Which is also mentioned in the information bulletin itself for the need. And my lord, in this regard, I like to.
So what is the instruction? Any relevant instruction?
Any relevant instruction, my lord, regarding counseling.
No, yes.
I like to show that the NEET is a part of this admission process, continuous process of admission, which start by NEET and subsequently counseling comes, which is not separate and independent. It is from the NEET which have been selected, out of that candidates only counseling has been conducted, my lord. And the counseling is also not independent, but it's also under the instruction of the medical counseling committee, my lord. My lord, in this regard, my lord, in my affidavit in reply, I have annexed the notification which is issued by Director of Medical Education Assam, my lord, on 6th of August.
Page?
At page 227. Last but second, my lord. Where?
Yes.
Wherein it is mentioned that this is for information of all concerned that in pursuance of the revised counseling schedule published by the MCC, Government of India, on 5th August 25, and in partial modification of education notice of Directorate by number even, so even the date of publication of the result, first round online counseling for admission into first year MBBS courses in government medical and dental colleges for session 25 under state quota seal fee, 18th of August. Wherein it is clearly revealed that the counseling authority doing each and every act as per instruction from the MCC. Only separate application for counseling is required because the candidate who have applied selected through NEET for all over India and for state quota seats, the willingness to know the willingness of candidates, the separate notification is required, my lord. Otherwise, my lord, the counseling is upon the candidate who have earlier selected by NEET only appeared before the counseling authority for counseling, and they may, if selected, then got seat and admitted.
Earlier, the CBSE was conducting the exams. Now it's the
Now NTA.
NTA.
Yes, Your Lordship.
Then MCC is also done away with.
My lord, MCC is constituted under the National Medical Commission Act.
We have the MCC till now.
Yes, Your Lordship.
Of course, MCC,
Yes, Your Lordship.
Medical Counseling
Counseling
Committee. What is that no longer done? We have in 2020. What was that, Mr. Gogoi?
That is the NCI, Medical Council.
MCA is no more.
Medical Council of India.
Okay.
That is the main apex body.
That has been replaced.
Regulate the entire medical education in the state of Assam.
That MCA has been replaced by
By National Medical Commission. NMC.
Okay.
They issued a various regulations now, now, madam, in 2020.
National Medical Commission,
Yes, ma'am.
which is under enactment, isn't it?
Yes, my lord. The name of the act is the National Medical Commission Act 2019.
2019.
Yes, Your Lordship.
And under the NMC, the MCC has been, MCC is under the NMC, isn't it?
Yes, Your Lordship.
And the state by itself cannot conduct the counseling. So
Yes, my
it
lord.
has to come from the
MCC.
MCC. So thereby you're saying that whether it be NEET or whether it be the ultimate selection.
Counseling is the subsequent part of NEET, my lord. Beginning is NEET
uh,
and subsequently counseling conducted by state under the instruction of MCC.
What you're saying, it's only a different stage, that's all.
Different stage only.
Process is one only, but two stages.
Yes, Your Lordship.
Mr. B. Gogoi says, no, it's different.
Yes, my lord.
That is where you differ.
Yes, my lord. My lord, there is no any independent entrance test for the state of Assam. Because as per the Act, National Medical Commission Act, the common admission entrance test has been conducted by the NTA as per section 14. My lord, for consenting this common admission test, my lord, the state has issued a education notice dated, my lord, 8/2/2017 itself, my lord. Here it's stated, this is for general information to all concerned candidates that there shall be no state level medical entrance test in Assam for selection of candidate for admission into MBBS BDS courses in the medical colleges of Assam and regional dental colleges Guwahati from this year onwards. It is, I have annexed as annex 12 to my writ petition at page 53. Writ petition, my lord. Yes, ma'am. This man, my lord, let him, if required, I will reply.
But I will refer to the information bulletin first, man, to clarify what is the role of NTA and what will be the role of the counseling approaches. Just to a certain clause, on the last occasion I have already referred to. Procedural page 92 of the affidavit. It's chapter 1 of the information bulletin. Possible similar, the 1.1 about National Testing Agency. The national eligibility entrance test. It is, my lord, is an entrance test, and it's not a authority. It is being conducted by the NTA since 2019 for admission to the undergraduate medical education with the approval of the Ministry of Health and Family Welfare. Wide OM dated 6th of December 17 and MHRD dated 24th of September 2018. Also, you will see the Ministry of Education, Government of India established the National Testing Agency as an, Lordship will see, as an independent, autonomous and self-sustained premier testing organization. It is nowhere connected with the counseling body under the Societies Registration Act for conducting efficient, transparent and international standardized tests. Again, my lord, we will say only for tests in order to assess the competency of the candidates for admission to the premier higher education institutes with a mission to improve the equity and quality in education by developing and administering research-based, valid, reliable, efficient, transparent, fair and international level assessment. NTA strongly believes in the quality, efficiency, and so. Now, objective. Objective of NTA inter alia include to conduct, Lordship will mark this one, my lord, to conduct efficient, transparent and international standardized test. Again, my lord, this is limited to test in order to assess the competency of candidates for admission. They will conduct the NEET exam and the results will be forwarded to each state, my lord, of the country. That is their limited role. Now, Lordship will see, my lord, again in the next page, page 94. What is NEET UG exam and role of NTA for the NEET? 2.2.1 says the NEET UG 2025 is going to be conducted by NTA. So the exam is going to be conducted by NTA as per the schedule given in the information at a glance for admission to MBBS, BDS, so courses as per the relevant norms, guidelines, regulations notified by the concerned regulatory bodies of the Indian system of medicine in all medical institutions governed under this act. Well, this exam will be conducted as per the regulations issued by the Indian system of medicine and in all medical institutions governed under this act. So only for the test part, my lord, this is there, NEET, NTA. And that too, my lord, as per the schedule that has been, my lord, that will be notified by NTA. Only NEET exam. I will place that also, my lord. Now, Lordship, 2.3.1. The responsibility of NTA is limited. On the last occasion, I said, Lordship, can you mark this word, my lord, limited. The responsibility of NTA is limited to inviting online applications, the conduct of the entrance test, declaration of results, and providing all India rank to the Director of Health Services, Ministry of Health and Family Welfare, Government of India. Their need NTA even, my lord, doesn't, my lord, forward the list to the state. It is the Ministry of Health and Family Welfare who should provide it to us, to the state. Lordship will mark this, my lord. The responsibility is limited, my lord, to the invitation of so-and-so, the conduct of the entrance test, declaration of results, and providing all India rank to the Director General of Health Services, Ministry of so-and-so, Government of India. So Director General of Health Services, my lord, they forward the state list, my lord, to us for conducting the, my lord, state quota 6 counseling. Now, my lord, 2.3.2, again, my lord, the information contained in this information bulletin relating to the pattern of exam, syllabus, eligibility criteria for appearing in NEET UG. Whatever criteria has been prescribed in this information bulletin is only limited to the appearance eligibility of the particular candidate to appear in NEET, not for counseling in the state quota. The quota of seats, reservation, so-and-so, admission norms, procedures to the so-and-so are as per the norms set out by the respective regulatory bodies. Lordship will see again 2.3.3, the result and all India rank of NEET UG will be prepared, notified by the NTA as per the norms, criteria fixed by NMC. So-and-so, well, it is only the results and all India rank, that will be prepared by NTA as per the norms or criteria fixed by NMC. That is the National Medical Commission, Director General of Health Services for MBBS, BDS, and so-and-so for the other courses. Now, Lordship will see, my lord, next, my lord, the eligibility criteria, page 103. It is 5.1, my lord. Just one line I will read because that eligibility criteria is not relevant for us. It says, my lord, 5.1, eligibility criteria to appear in NEET UG. Eligibility for appearing in NEET UG as per related regulations of so-and-so are as follows. My lord, this eligibility prescribed in the, my lord, information bulletin is only limited to the extent of eligibility of a candidate to appear in the, my lord, NEET exam only. For the state quotas, there are separate eligibility criteria as per the regulations that have been issued by the Director of Medical Education, Assam, like in the other states. My lord. Then my lord, relevant my lord, page 110. Admission procedure, my lord. Now, you will see now, my lord, the admission procedure starts after the results have been declared by the Directorate of Health Services. 6.1.1 admission to all seats of undergraduate dental courses will be done through NEET UG. The following are the seats available under different quotas. First is All India quota. Second is state government state quota seats. That is the state quota seats. Now 6.1.2 says the counseling for admission to the seats under the control of state government, union territory administration, state universities, institutions shall be conducted by the designated authorities of the state government as per notifications issued separately by the concerned authority. Well, this is very relevant. So far as our role is concerned, of the state for filling up of the state quota seats, it will start only when the designated authority of the state will issue a separate notification in this regard. That notification is, already placed, that is 1st of July 2025. So the game started in, so far as the counseling is concerned, on 1/7/2026. So far as the present counseling of that, Lordship will find in the writ petition. There in the affidavit also. At page, Lordship will mark it, page 50. For the first time, this has been issued, it has been relied upon by the writ petitioner also, that for the first time, the state of Assam will issue the notification on 1st of July 2025. This is the first notification that was issued. Then thereafter, it has continued, various notifications has come up, but this is the first one. And if Lordship is taking up the writ petition, just one page, last page, he has relied upon one document, page 53, just I want to clarify now itself, page 53. Last annexure 12. Unlike this year, which has been issued in 1st of July 2025, in 2017, the first education notice was issued on 8 to 2017. This will have a very relevance in this particular case. There it was issued in 2017, in February 2017 itself. But this year it has been issued in 1st of July. So that I will place while differentiating that particular judgment of the Honorable Court passed by court levels. Lordship will say there the first notice was issued in February 2017. Here, 2025, it is on 1st of July. That's I am referring to. Now, Lordship will again come to page 110 of the affidavit. That is a notification of 2017, which came in February. Much prior to the amendment that was brought in 2017, August or July, I suppose. So page 110. 6.1.3 again relevant. The result of NEET UG 2025 may be utilized by other entities of the central and state government in accordance with their respective eligibility criteria. Again, their respective criteria. Other norms, applicable regulations, guidelines, rules, etc. Now, Lordship will see in the next page, 111, 6.1.4. While filling up the NEET form, they are supposed to give a declaration as to which category they belong, which state they belong. And by this clause 4.1 or 6.1.4, during counseling the eligibility criteria, self-declarations, all the uploaded documents, etc. of the eligible candidates shall be verified as per norms specified by the respective authorities. During counseling, respective authorities will verify their documents that they have uploaded in while appearing in NEET for the state quota seats. This is the stage where we will verify. They claim that they are eligible for the state quota seats, but finally, that authority to have the final decision is the state, not the MTA. 6.1.4. During counseling, the line starts, during counseling, the eligibility criteria, self-declaration, all uploaded documents, etc. of the eligible candidates shall be verified as per norms specified by the respective authorities. It is the state who will verify as per our regulations. Now, Lordship will see 1.1.5, it is regarding other course. Now, 6.1.6, very relevant. The fourth line, 6.1.6, my lord. The fourth line, my lord, the NTA lordship has found that the NTA will not. The fourth line, my lord.
Yes, yes.
The NTA will only provide all India rank to the candidates, while admitting authorities will invite applications for counseling and a merit list shall be drawn based on all India rank by the admitting authorities. He said NTA will only provide all India ranks to the candidates, while admitting authorities will invite applications for counseling and a merit list shall be drawn based on all India rank by the admitting authorities. Admission to undergraduate medical courses within the respective categories shall be based solely on the all India rank so and so. So, my lord, that rank we will have to follow. We cannot conduct a separate, my lord, entrance examination, but counseling will be as per the relevant norms of the state government. Next, my lord, 112. A says admission in state medical college, universities, institutions, private medical college for seats other than 15% all India quota. So it will be state quota, other than all India quota. 15% all India quota. So whatever criteria is in Roman 1, 2, and 3 will be for the state. A1 says admission under the state quota shall be subject to reservation policy eligibility criteria prevailing in the union and state and the union territory as notified by the respective state or union territory from time to time. Here, my lord, it has been amended, and the 2025 regulation is a prevailing rule, my lord, or regulation that will prevail for this counseling of 2025. That is my humble submission. This part prevailing norms, my learned friend want to point out that, my lord, prevailing norms will be the norms which was there when the first education notice was issued by the NT. My humble submission will be, my lord, referring to clause 6.1.2, which says that but there will be a separate notification, page, my lord, 110. 6.1.2, it says, my lord, that as per the notification issued separately by the authority concerned, that is the counseling authority. Our role will come only when this notification is issued by the Director of Medical Education Assam. After we get the merit list from the central government, my lord. It is NTA will only prepare, they will not forward it to us. Their role is limited to preparing the, my lord, conducting the examination and preparing the merit list as per the prevailing regulations of the, my lord, apex body. That is the NMC. Now, my lord, lordship will see. D, my lord. It is A, lordship will see in the next page D, page 113. For all institutions wherein counseling is conducted by the state, union government or its designated authority, the candidates may refer to the counseling notifications issued by the state or union or its designated authority so as to determine their eligibility to appear. Now, what more is required? The candidates may refer to the counseling notifications issued by the state or union government or its designated authority so as to determine their eligibility to appear in the counseling for the subsequent rounds, including in the respect of ineligibility on account of the allotment of seats in the previous rounds of the counseling terms of so-and-so. Now, my lord, one clause my learned friend has referred to is page 120, 6.4. I want to reply to that. It's regarding reservation in central institutes and universities. We have referred to this reservation quota in state in the second paragraph. Reservation in the state quota seats, universities, institutions, private medical colleges under the state government. In case of seats filled up by the state medical college, so and so, the reservation policy of the concerned state government shall apply. Now, my lord, coming to 6.6, my lord. This is, my lord, instructions for counseling by the MCC. Medical Counseling Committee for MBBS, BBS admission. One says, my lord, online counseling would be conducted by the Medical Counseling Committee of the Directorate General of Health Services for undergraduate medical courses. Now, lordship will directly come to Roman 2. Just for Roman 2, my lord. MCC is conducting counseling for 15% all India quota, not for the state quota, my lord. Very clear, my lord. Lordship will read the Roman 1 and Roman 2, my lord, first lines. Roman 1 says online counseling will be conducted the medical counseling committee of the Directorate General of Health Services for undergraduate medical courses. Information for online counseling would be applied so and so. This is for for whose seats, what seats, it is Roman 2. MCC is conducting counseling for 15% all India seats, MBBS, BDS of states. And they will participate in the counseling from so and so. 100% MBBS seats of Bhopal University, I don't know. AIMS will come in, my lord. It will be under MCC. JIPMAR will be under MCC. AMU open and internal seats will be under MCC. 85% internal quota domicile seats of DU, so and so. So whoever falls under MCC is categorically mentioned here. In the state quota seats are not here. State quota seats has been already mentioned in clause page 112, part of 6.1.6. Page 112, it says again, for the sake of repetition, admission in medical college, universities, institutions, private medical colleges for seats other than 15% all India quota. So it's a 85% state quota. It will be as per the regulations, so and so. And in D it says, my lord, that page 113 says, my lord, as per the notification issued by the designated authority, so as to determine the eligibility to appear in counseling. So to appear in the counseling, there is a separate set of eligibility criteria fixed by the, my lord, counseling authority. Now, my lord, page 124, lordship is very relevant, my lord. Page 124, clause 7.1.1. Merely appearing and qualifying in NEET UG 2025 does not confer any right to the candidate for admission to the undergraduate medical courses. The selection and admission to so and so seats in any medical institution recognized for offering undergraduate students, subject to fulfilling the admission criteria, eligibility, rank in the merit list, medical fitness, and such other criteria as may be prescribed by the Government of India, respective states. Government of India will prescribe for the 15% all India quota, respective states for the 85% quota. So it's very clear, madam. It is the NTA guidelines says so. And my lord, 7.1.8, my lord, one line I read. Candidates eligible for NEET UG 2025 is purely provisional. It's purely provisional. No right accrues, my lord, a person who is eligible in NEET. No right accrues, my lord, for admission until and unless he qualifies in the quota state quota seats as per the prevailing regulation of the state. Now, lords, you will see, my lord, the writ petition, page 21, annexure 1. Lords, you will kindly mark the dates, my lord, 3-4 dates will be there. This is the public notice issued by the National Testing Agency on 7th of February 2025. This is the first notice issued by the National Testing Agency for this year on 7th of February 25. Here the last date of submission of application for NEET exam is 7th of March 25. Lords, you will see the chart. First, online submission of application form from 7th February to 7th of March 25. Then, my lord, date of examination is 4th of May 2025. Lords, you will kindly mark this one. Without any postponement, my lord, on this particular very date, the examination was conducted. And the date is, my lord, 4th of May 2025. The amendment came on, my lord, 9/4/25. Prior to 1 month.
Yes.
And, my lord, the results were declared in the last column row of the chart, my lord. On 14th of June 2025, the results were declared. The rule came in, my lord, 9th of April 25. And my lord, this particular public notice is limited to the extent of holding the exam only, my lord. There is nothing about counseling. What the authority says is, my lord, page 22, lordship will see the last second para in the next page. The candidate who desires to appear in NEET UG 2025 may see the detailed information bulletin available on the website for instructions. So they are to, my lord, go through this particular information bulletin and only thereafter appear. And the information bulletin has made it clear that, my lord, the role of NTA is limited to the extent of holding the examination, preparing the, my lord, merit list, and submitting it to the Directorate of Health Services, Union of India, who will thereafter forward it to the state as per the options made by the various candidates for their respective state quotas in all India quota. Now, my lord, in the writ petition itself, my lord, page 26, this is the scorecard, the result of the writ petitioner. Here, down below, the important information, my lord. Again, my lord, they have been informed on the day when the results were declared that NTA, lordship will say point number 5. NTA has decided only NEET all India rank.
Declared,
My lord.
not decided, declared.
Declared, my lord. Declared on only NTA, NEET all India rank. Counseling authorities will invite applications from the successful candidates and prepare their own merit list as per their needs. First, you will see very clearly, my lord, they have informed the moment they issued the scorecard, their role is over. They said that now for the counseling, it is the counseling authorities will issue, my lord, as per their own rules. Now, 7 says the NEET UG 2025 result. In the NEET UG 2025 results, the category of the candidate is as per details submitted by them in the online application form. In case, if the category of candidate falls under any other category, in the state category list, candidates may apply to the designated counseling with their category as per so-and-so. Supposingly, my lord, in the particular case of the present petitioner, here he has, lordship will see, my lord, page 26 itself, the category. In the middle, my lord, there is a row, there is an option, my lord, to show their category.
General EWS.
Yes, my lord, he has declared it as so-and-so, but on the date of counseling, if at all, my lord, that common part, my lord, 5% reservation is available, then of course you can apply for that in addition to this particular declared, my lord, reservation. But unfortunately for this year, my lord, that has been omitted in the amended rules. Because the 7 is very, may I read it again, my lord, clause 7. In the NEET UG 2025 result, that category of the candidate as per details submitted by them in the online application form. In case, if the category of candidate falls under any other category in the state category list, candidate may apply to the designated counseling authority with their respective, so with their category as per state category list, and designated counseling authority will verify so-and-so. Had it been, say, my lord, this time, my lord, that 5% is there. Addition to, my lord, general EWS, he can apply for that 5% also, if it is available in the state regulation. That is what is prescribed here.
Mr. Gogoi,
Well,
tell me one thing, this Act of 2017, isn't it?
yes, my lord, you will see. In the reply, they have brought in, my lord.
Where do we have that Act of 2017?
118, Lord, you will see page 118. It's part of the reply.
118. What is the purpose of this act?
But this is a regulation for conducting the counseling in the state of Assam for admitting students under the 85% state quota seats in the medical colleges of the state. This is the purpose.
So ultimately, this is the thing which has to be
Yes,
looked
my
into.
lord, you will see. This has come into force, page 118. Well,
No,
after this, my lord,
118
page 118
of
of the, my lord, reply that they have filed today. Running page 118. 118. Today's reply, my lord.
Actually,
118, 218.
218. Oh, my interest.
Oh, you have given separate pagination.
Oh, in my, it is not correct.
He also was saying 118.
But 218, yes, page 218, Lord, you will see, my lord. This particular rule which was published by notification dated 1st of July 2017. This came into force on 11th of July 2017. Lord, you will see at the top.
Correct.
Published by the authority number so-and-so dated 11th July 2017. Now, Lord, you will see, my lord, 1, clause 1, subclause 2. They shall come into force on the date of their publication in the official gazette. So it was published on 11th of July 2017.
Yes.
So it will be effective from that particular date.
Okay, no.
So now Lordship will see, my lord, Lordship will remember I have pointed out to the one annexure at page 53. These two dates are, my lord, relevant. 53, my lord, of the writ petition. That, my lord, education notice dated 8/2/2017, issued by the Director of Medical Education, Assam. In 2017, my lord, the educational notice was issued on 8/2/2017, and the amendment was brought on 11th of July 2017. March after the, my lord, that education notice was published by the same, my lord, state, that is the Director of Medical Assam. That's why Honorable Court said that you have started the game in, my lord, February 2017, and on the flagrant of the, on the eve of the counseling, you have brought in the amendment. So that is not permissible. On 11th of July 2017 was the date of counseling also, madam. On that day, hurriedly this was brought in and said that forget about the other rule of 2015, now it will be 17. So Honorable Court said that that is not permissible. You have started your game in, my lord, February 2017. By this notification dated 8/2/2017, which is at page 53 of the writ petition. Now on the eve of counseling, you cannot bring in a new amendment. But in the present case, my lord, on 9/4 itself, my lord, the amendment has been brought in 2025.
What was the purport of this page 53?
53, it says, my lord, ultimately it is a Director of Medical.
No entrance exams.
Yes.
No entrance exams.
So it says, my lord, state will not conduct any entrance examination. It will be the All India NEET, my lord, exam, which will hold the field so far as the entrance examination is concerned.
Then what does 2017 say? Exams?
It says exams. So we are notified on that day.
Oh. Which part?
Lordship will see the first. It is for general information of all concerned candidates that there shall be no state level merit entrance test.
No, no.
Earlier it was the state,
No, in 2000, by 2017 Act,
my lord.
was the exam provided?
No, no. Act does not provide for, my lord. It is the MCI at that point of time prior to 2017. MCI used to, my lord, has authorized every state to have their own entrance examination. Earlier it was conducted by the Dibrugarh University of the state.
So is that provision available in 2017 Act?
Well, not there. Entrance exam, no, it's not there. Lordship will see, my lord, page 119, the 2017 rules. The definition, my lord, number 8, Roman 8. Examination conducting authority. It says, my lord, it means any authority as may be decided by the government of India from time to time to conduct the NEET. So NEET has for the first time been brought in this regulation in 2017. Because the scenario has changed. Earlier it is JEE, Joint Entrance Examination, madam. The Dolly Sadda's case, madam, of 2003, that particular entrance is mentioned. Every state used to have their joint entrance test. That is applicable for both medical as well as the engineering institutes of the state at that point of time. Assam also had their separate counseling. From 17 onwards, my lord, that NEET has been brought in as a uniform, my lord, one time, my lord, counseling entrance examination where every candidate from the state will have to participate. So that the standard of examination remains the same. That is the main objective, man. So Lordship will see, so far as, my lord, this page 21, my lord, my humble submission will be, my lord, this particular notice itself speaks that the role of NTA is limited to the extent of holding the examination and declaration of the result. Because the chart ends at last, my lord, row, declaration of result by NTA exams, so. And my lord, I repeat, my lord, in 2017, unlike in, my lord, 2025, there, my lord, the education notice was issued in February itself. At the same month when, my lord, that time CBSE has issued the education notice.
So what is this educational notice? The purpose?
So, by this notice, my lord, candidates have been informed that, my lord, from now on, it is NEET, my lord, will follow. Will have to be followed. The state is not going to hold any separate examination.
No, you're comparing this with the one issued in July.
Yes, my lord. My lord, in
Why?
2017, no, that I will, that will be, that dates will be relevant while I will, my lord, refer to the judgment of this court and bench of the honorable court. Where, my lord, earlier in 2017, some similar candidates, they approached the honorable court. This honorable court held that, my lord, the amendment, this particular amendment of 2017 will not be applicable for the session 2017. For the very reason that, my lord, we have issued this educational notice on February 2017, and the amendment was brought in on July 2017, 11th of July 2017.
Where's the judgment?
Yes. My lord, that my learned friend has placed it, my lord, on one copy. That is, my lord, WPC number 4174, or she is holding it, but 4174 2017. Lord, she will see, my lord, para 6. Para 6. Relevant dates for 2017 admission. Lord, you have got it, man?
Yes.
Lord, you will see that it says the director of medical education on yes 31/2017. Lord, you will see the first date. CBSE issued the notice for NEET UG examination for admission to MBBS BDS course for the session 2017. So it was on, my lord, 30th of January that notice was issued, unlike here in, my lord, in the present case in February 2025. Now on, my lord, 8th to 2017, the Director of Medical Education Assam issued the educational notice to inform that in order to secure admission to either state quota seats or the All India quota seats for the session 17, the aspirants are to apply through NEET UG 2017 conducted by the CBSE. The candidates were also advised to visit the CBSE website for the online application and also to gather information on other details regarding the NEET UG 2017 examination. Gather information else. Now, my lord, on 7/5/2017, NEET UG examination was held. On 23/6/17, results were declared. 1/7/2017, Assam State Merit List was released. 3/7/17, educational notice issued by DME Assam for admission, inviting application from those in the Assam so-and-so, indicating the reserved category seats for 12 groups and specifying the schedule for admission, with first round counseling commencing on 16 July 2017. Now, let's see the next one. 11/7/2017, the admission notice issued by DME Assam specifying the date which the candidate as per their date rank are to appear for the respective counseling session. On the same day, 11/7/17, the gazette notification bringing into force the admission rules 2017. So, my lord, March after the, my lord, educational notice was issued, and, my lord, the counseling process started. The, my lord, amendment was brought in 2017. Unlike in this year, my lord, where, my lord, we have gotten in April itself, and the counseling process started from 1st of July 2025 by that particular education notice. And, my lord, what was the issue before the honorable court at that point of time? It was the retrospective effect of that particular, my lord, amendment. Whether, my lord, in a particular rule that has been brought in on 11th of July 2017 can be made applicable to a counseling process for admission to the state quota seats, where, my lord, the educational notice has already been issued prior to that amendment, my lord. On the eve of that, my lord, admission process, or on the day when, my lord, the candidates were supposed to take admission, this particular amendment was brought in, which is not the case in the present, my lord, scenario. Present scenario. Lord, you will see, my lord, 16, my lord, that was the issue. The above ratio makes it amply clear that the authority to make rules or regulations with the retrospective impact is circumscribed. Therefore, unless the authority is vested with the so-and-so, so whether, my lord, retrospectively we can apply it or not. Here, my lord, we have just come before and when. That's why, my lord, no appeal was preferred against this judgment by the state. And, my lord, what was considered by the honorable court, Lord, you will see, my lord, just 2-3 lines I would like to point out. Lord, you will see para 12.
See, Mr. Gogoi, one thing.
Well,
If you come to para 25,
well,
it says the period for application for this year's admission was scheduled during so-and-so, so-and-so.
my lord.
Para 25.
Yes, sir. The Supreme Court in Dolisata.
No, skip that.
No, I will differentiate that, my lord. This
No.
particular judgment will be applicable in our case also, my lord. Lordship will see the period
The period for
application
application.
notice admissions was scheduled during 31/17 to 1/3/17.
Ah,
And hence the eligibility for the petitioner must be with reference to the last date of application, that is so and so. Therefore, the admission must be granted on the basis of the norms prevalent. Here, my lord, may I pause, my lord, Lordship will see the final, what is the order passed by the honorable court. And my lord, whether in 2017 this information bulletin was there, my lord, clarifying, my lord, the two different, my lord, phases of selection. And not a single whisper in this particular judgment about any information bulletin issued by the CBSE at that point of time.
That time it was CBSE.
Yes, my lord. This time NTS clarified, my lord, repeatedly in various clauses.
But this period, 31/17 to 1/3/2017,
My lord.
is it comparable to what has been issued here in the first day? Can you compare it
Yes,
to
yes.
the
There was, my lord, going by, my lord, that.
public notice?
Yes, my lord, it is there. It was sometimes in March.
Public notice also says 2nd February 2025.
My lord, there is no doubt regarding that, but my lord, what is the, my lord, finally, today's position is different, my lord, that's why I am saying, my lord. The NTA made it clear in the information bulletin, my lord. Now, may I read further, my lord? Lordship will say, para 28 for a moment.
No, definitely it's different now.
No, Lordship will say, para 28, what the finally the honorable court, what honorable court has said. Para 28 for a moment, what is that? That is the main, my lord, part. The quest for admission for medical studies began for the petitioner months earlier, well before the admission for 2017 was gazetted last month on 11th of July 2017. The norms for the OBC MOBC did not envisage any creamy layer category when the candidates applied. Even at the stage of examination, Lordship will see mark this particular line, madam. Even at the stage of examination or declaration of results, test results, the admission norms did not exclude the creamy layer so and so, meant for so and so. Therefore, Lordship will see, madam, mark it. Therefore, when the admission right gets accrued on the basis of the results of the entrance test, here, my lord, the results came in, my lord, May. Results test, entrance test, it will be highly arbitrary to exclude the creamy layer of the so and so on the basis of the same norms notified by the on the eve of the council. So, my lord, their right accrues, my lord, loss. Honorable court is held on the day when the examination was held or on the day when the results were declared. Here, my lord, the examination and results were declared much later. 14th of May, my lord, the examination was held. Result was declared sometime in 16th. Fourth of May, my lord, the examination was held. Result was declared on 14th of June. The amendment came in, my lord, 9/4. The honorable court categorically said that, my lord, their right will accrue on the day when they appeared in the examination.
Okay.
That's the, my lord, main, my lord, fine difference, my lord, between that particular case and the present, my lord, situation today.
Mr. Gogoi, we'll continue with this matter tomorrow.
My lord, fine.
And there's so many other matters. later.
Yes, my lord. In
More or less, we are done with
So it was 12 was the last date. It has been now extended till 18.
18.
Yes.
That's
So
good.
let it be tomorrow, my lord. At least we can complete.
What is the situation tomorrow? Hearing.
Well, this may be given the priority, my lord.
We'll give
Let
this
it be
priority
tomorrow.
morning, you make a mention.
Yes.
Now, only thing is that should we take a call on the interim part or take a decide?
Here's the final part. Again, my
Final
lord,
part.
we will be in trouble. Because, my lord, we will have to complete the process, my lord, within the time. Because majority of the seats will be over on that. Only the three vacancies will remain, my lord, in the last round of vaccine. If somebody wants to join All India quota, somebody might have post for another course, then, my lord, whatever vacancy remains, they are ultimately filled up.
Okay, just a minute.
Just once.
We'll have it on Wednesday. Tomorrow there's some part hard matter. So that's why some difficulties there.
Then also
Okay.
see that two minutes basically. That two on.
Somebody remind me that on that day.
Yes, sir.
It's not in the order. Yeah. This matter again on so and so.
This case, my lord, I have communicated so many times, my lord, the petitioner is not interested, my lord. And he may receive, my lord, as per court order, my lord.
Petitioners are interested.
My lord.
What happened then? This is
Regarding, my lord, share of the, my lord, family pension, my lord. And court order dated 10/9/2019.
you're for the petitioner, isn't it?
My lord, but I have written, communicated on written, my lord, but he has not come forward, my lord. My lord, as because, my lord, I have to file the impleadment petition also, my lord, the income can also send, my lord.
What is to be done then? Should we issue notice directly to him?
My
To
lord.
her?
Asia Khatun, petitioner. My lord, it is
Better issue notice to her.
It is better, my lord.
Mr. K.R. Padgiri, learned counsel for the petitioner, submits that although he has written to the petitioner, but he has not received any response till date. Stop under the circumstance, the registry shall issue a notice to the petitioner in the address given in the cause title, making the same returnable by 24th of September. List accordingly.
My lord. Obliged.
May it please your lordship. Lordship, may peruse the last order dated 14/7/25.
Yes, 37 losses. I have received my instruction. Let me find an affidavit losses. I'll bring it to an affidavit losses. We have already complied. They were given the benefit of pay scale in 2021 itself. Both the petitioner. Losses direction was at page 38, losses para 6. Accordingly, these two petitions dispose of directly the respondent authorities to examine the claim the petitioner's losses and grant of regular time scale of pay to the petitioners as has been directed to be given in similar situated persons in terms of the direction of the Honorable Court in WA number 233/2017, which however be subject to any order passed by the higher judicial forum in this regard from the date of initial appointment. And accordingly, they were given the benefit of time scale losses in 2021. Now
So-
we're getting the time scale losses.
Lordship, let them file the affidavit, your lordship. He may be permitted.
Let me bring all this to an affidavit losses by losses can fix it on next week.
After a week.
I'll find it.
Okay. Mr. SMT Chisti, learned counsel for the respondent. Respondents
Yes, yes.
submits that he has received instructions and may be allowed to file the same by with an affidavit. In view of above, list this matter again after a week for a date to be fixed by the registry. Your good name?
I am KJ Saikya, Your Lordship, on behalf of Mr. R.S. Mishra.
Mr. KJ Saikya, learned counsel appears for, learned counsel appears on behalf of Mr.
R.S.
PJ Saikya
PJ Saikya.
for the petition, for the petitioners, yes.
Deeply obliged.
Yes, what is this?
Lordship, here we also need accommodation because on earlier occasion, Mr. Aramudina, he was appearing. We have to gather the brief from him, Lordship. And moreover, on last two occasions, I have seen that petitioner were not appearing, Lordship. And here, Lordship, PTC is the main party. PTC is also required necessary party, Lordship. I have seen my instruction that director has already written to the director of BTC, Lordship, for some communication regarding some proposal. So BTC is also a necessary party in this case. They were party in the writ petition also.
So sometimes the respondents are appearing and sometimes petition is appearing,
Yes.
turn by turn.
For last two occasions, they were not appearing.
No.
Ah.
On 10/2/25, respondents did not appear.
Yes.
On 10/3, petitioner did not appear. And likewise on other dates also.
And let it come after 2 weeks, Lordship. Given that I'll have to appear and I'll bring them instruction, Lordship.
All right, whatever instructions you have, you file it.
Yes, sir.
None appears for the petitioner when the matter is called. Mr. SMT Chisti, learned counsel for the,
I am for Lordship, on behalf of Mr. N. Fupon, that may be recorded, Lordship, because N. Fupon also on, along with Mr. Armodin, so on behalf of N. Fupon, I'm
Mr. SMT Chisti, learned counsel appearing on behalf of Mr. N. Pukan, representing respondent.
one Lordship, he has already been retired.
3 is still there.
3 is still there.
Narayan Kaur,
Yes, he is still there.
representing respondent
Yeah.
number 3, raised for him and is granted 2 weeks' time to obtain instructions and to file the show cause reply. Prayers allowed. This again after 2 weeks on a date to which perfects.
Petitioner were supposed to file impleadment petition, Lordship.
Lordship, in the last order, the Honorable Court has directed to file impleadment petition, but we unfortunately could not file an impleadment petition because, Lordship, we are unable to contact with our clients, Lordship, for further instruction. Can the 4 weeks time may be given, Lordship, to file impleadment petition?
You file what?
To file impleadment petition, Lordship,
Okay.
for impleadment of new income and Lordship.
Okay, but in the meantime, who's there for the other side?
Lordship, in probably it is on the elementary education, Lordship. I think earlier all the respondents, they were all retired long back, Lordship.
You're appearing for whom, Mr.
No,
Chisti?
no, I'm just for the elementary education. Please written is elementary education, Lordship. So let them file impleading petition.
No,
The new incumbent.
no,
appear, Lordship.
impleadment, okay, that we may allow, but the thing is that who had appeared last time for the respondent? B. Kaushik, then A. Chaliha. But this is by way of the standing council.
Yes, yes.
Do you appear by way of,
Sometimes
in your
court
capacity as standing council?
Sometimes court, honorable courts allowed us to be appear on behalf of the standing council as a department.
Well, that's not correct.
But sometimes it's error. That's
Because
why
it's by name, it's by name.
Yes.
So
that is
you
why-
you have
that is
to
why
appear.
In the cost list, it is written as SCA, limited education lawsuit.
That's not correct.
Anyway, let them file a repeating lawsuit.
It
Let
should
them lawsuit
be,
go. It should, yes,
it should be by way of power,
yes, yes,
because this is a contempt.
yes, yes.
So no one had appeared anytime. And if you see the order, what the order says is that consider the representation. And if they're found eligible for the benefit, give them, that's all. Your good name, please.
Lordship, I'm MSK Saikia, Korobi Saikia, Lordship.
As paid for by Ms. K. Saikia, learned counsel for the petitioners. Further 4 weeks' time is granted to file appropriate application for impeding the respondent's consent. List again after 4 weeks on a date to which is released.
Obliged, Lordship.
40, you have issued a compliance order. I have given a copy to my friend Lordship. Let Lordship may take it up after 10 days. Let him bring the instruction whether his petitioner has got the order or.
Order was,
Or I will file an affidavit also. Through an affidavit, I will bring it to the.
I received this order and copy to given the petitioner, but nothing to say I'm going to join or not.
No, it's an appointment order, Lordship. It's an appointment and regulation orders.
Appointment.
Yes, regularized with effect from 2004, Lordship. Lordship may kindly peruse. I will file an affidavit, but Lordship may kindly peruse it.
If my learned friend Samit, I'm going to join, then your lordship will observe that my lord, I'm going to join. But my name is just serial number 8, Dipti Das.
No, see, let me get the story first. Where is the order? What does it say?
No order, my lord.
Page 28, Lordship.
28.
No,
No.
page the 28.
Yes.
Annex
28.
Second time litigation, my lord.
Okay, 28.
Yes, my lord.
Order dated 17/3/22.
My lord.
What is the direction?
Direction was given, your lordship.
Remanded back.
Para 13, remanded back.
Set aside the earlier order, removal order, my lord, and therefore they are passed and directed to make an independent, my lord, assessment on the claim of the period without binding itself to a requirement judgment so and so. And your lordship go to it, page 35, my lord.
Para 13 is a final direction, Lordship.
Paragraph 12, my lord. Paragraph 12, 11 and 12, my lord. 11, the second conclusion of the court was that the stand of the appointment of the petitioner is illegal as to two teachers who are appointed at the same post would also be unacceptable in as much as it is the petitioner who was appointed prior to other incumbent. Accordingly, the purpose of reconsideration, passing a fresh order, authorities were bound to judgment order at 5/9/2017 to pass its order only consideration after the two conclusion of this court. Resultantly, thereof the order, impugn order dated so and so has been passed. Upon perusal of order dated 31/10/2000, it is a noticeable that the commissioner and secretary had endeavored to make an independent assessment on the claim of the petitioner without binding itself to the requirement of the judgment dated so and so. The commissioner and secretary went to the question that the recommendation of the expert committee petitioner was in category where she was recommended not any kind of regulation of salary. Secondly, commissioner and secretary also again go back to the question that the petitioner was appointed against non-existing post. When there is an effective adjudication by the court that petitioner is entitled to parity with the 33 other teachers appointed pursuant to the select list dated 5/3/2001, and such judgment having arrived at its finality, the commissioner and secretary is bound to confine its consideration to the said aspect and not to venture out to make any de novo independent decision on the subject. From such point of view, the commissioner and secretary did not have the jurisdiction and authentication of the law to again go back to the question on recommendation of the expert committee in respect of the petitioner. and accordingly rejected her claim. What is noticeable is that Commissioner had not even considered the conclusion that this court that the petitioner is entitled to parity with 33 other assistant teachers who were appointed pursuant to the select list dated 5/3/2001, and that the parity means that her service is to be regularized by creating a supernumerary post by giving benefit with effect from 1/9/2004. The second reason of the commissioner and secretary that petitioner appointed against non-existing post, the same was also decided by this court by the judgment and order dated 5/7/2017 so that it is the petitioner who is appointed prior against an existing vacant post, and therefore her appointment cannot be constituted to be against any non-existent post. The conclusion of the commissioner and secretary appears to be conflict with the judgment of the court dated 5/9/2017. For the reasons stated above, the order of the commissioner and secretary 3110 is set aside. The matter again remanded back to the principal secretary to pass a fresh order, strictly taking note of the conclusion already arrived at this court judgment so-and-so dated so-and-so, which has already been referred herein above in clear and certain terms. The requirements of this order be passed within a period of 1 month from the date of. And thereafter, my lord, commissioner secretary, but pass an order, my lord. Your lordship is there, my lord, in flag by order dated, my lord, 7/2025. There is a flag, my lord. My learned standing council submitted before the honorable court. There is a flag, my lord, your lordship.
Yes.
Yes, my lord. So and so, I'm going to decision only, my lord.
Yes, then
Therefore, in compliance to honorable order, petitioner was heard in person in office chamber undersigned and concluded arrived at the honorable court have been taken into consideration. Accordingly, it is held that petitioner deputy is entitled to be regularized by creation of a supernumerary post. Hence, department has sought concurrent finance department creation of supernumerary post in respect of petitioner deputy das. I have now no school, my lord. I am there, my
Now
lord.
ultimately.
no, now the school is there.
Yes.
The school is there,
After
but
this, that the communication was shown to this court,
my lord.
21/7.
Director has issued this order.
And 21/7, we asked, what is this? Then today he has come up with this order showing that you are adjusted against Bhim Para Singori LP School.
Yeah.
Vice so-and-so retired. And benefit is given to you with effect from 1/9/2004.
Yes, from there.
So
Vacant post and subsequently adjusted as a stipend teacher
Hmm.
fixed 1,800 per month.
Hmm.
My all selected persons, same appointment, same, they are in regular in scale of payment. There
This
is,
you will also get lofty. This is.
there is no mention.
Because-
And my lord,
Regular-
last serial number 8, also not say you are going to go to join in the, your lordship, you observe that I am going to join
This
it,
is
my lord.
this is a regulation order. She'll have to join the lawsuit when she'll receive this lawsuit. Now I have given him a copy. He can send it to his plan lawsuit.
in terms of this order, let her join,
Yes,
isn't it?
yes.
What remains? Otherwise?
Nothing remains.
No, I am sorry for that, my lord. At least pending maybe because of that. So if honorable court permit me, 7 to 8 orders have been passed, similarly like that.
No, this is the first
So,
order.
so
for
my lord,
regulation.
I cannot, at least I am going to join and thereafter
What is your apprehension?
apprehension, my lord, if honorable court permit me, another order is passed on 21/7/2000. Last occasion, last
That is
before
the
that,
second-
they are also going, you
No,
go to
lawsuit-
join,
lawsuit
but
direct-
nothing.
Direction was given to the secretary. Secretary is not
My
the
lord,
appointing authority.
At least,
Secretary is
my
the
lord,
issued an order. Now
10
director-
days time, my lord,
director
10 days
being the
time after
appointing
that,
authority.
my lord, whether what is going on, my lord.
My lord, director being the
I
appointing
think
authority has issued this
there
order
is
for
no
review.
any clear,
Secretary
my
is not
lord,
appointing
what
authority.
amount I am going to. Because of that, I am to, because my problem is that when I am sending to the training, my basic training, my post will be given, I was given another person. That's why this problem is created first. And that was written in the honorable court's order, honorable court order, my lord. So, my lord, they are now saying, my lord, 1800, what they are given, I don't know. At least after 10 days, my lord. What?
Ultimately, we have created a supernumerary post. She was regularized with effect on 2004, 1/9/2004 lawsuit. And the director being the appointing authority has issued this order regularizing her service lawsuit.
And basic training, After completion of basically, I would, as per appointment earlier order, my lord, I have to be given a regular scale of pay. They is mentioning only 1800. At least at this stage, my lord, my contempt petition may be pending, and after 10 days, what will be, my lord, in this type of order, so many order has been passed.
No, this is only one order. Earlier, that order issued by the secretary of the secretary is not an appointing authority.
I don't know, my lord, that was submitted before the honorable court, my lord.
Now, director being an appointing authority issued this regulation order of it. The appointment order or regulation order has to be issued by the director itself.
What is this memo number ECF?
That is the order issued by the secretary lordship.
ECF stands for what?
Yes, lordship.
You have a copy of the order which
Yes,
you
yes,
gave me?
yes.
See the first line. Memo number, letter number, white number, so and so. What is this ECF?
Secretary order.
ECF. All orders is ECF, my lord.
ECF means I have been told those orders which are given by online lordship. The order which are issued online lordship, I think it was marked as ECF lordship. This ECF, this order was issued by the earlier, we referred to earlier order issued by the.
What is the full form? That's what I want to know, full form.
I don't know, I'll have to ask them lordship.
Your lordship, go to it, my lord, your lordship, by order dated 11/4/2025, your lordship.
I have been told that it is e-computer form.
Have a moment, my lord. By order dated 11/4/2025, my lord. If your lordship.
Mr. Chisti, then you file an affidavit.
Yes,
Yes, my lord,
that is
yes.
what I have submitted lordship. I will bring all these things.
My lord,
to an
by
affidavit.
order dated 11/4/2005, my lord, specific direction was given by the honorable on 11/4/2000. Within 2 weeks, well, your lordship go to 11/4/2020.
It's okay. Mr. SMT Chisti, learned counsel for the respondent, submits that he has received the instructions. And maybe given a week's time to file the same by way of an affidavit, praise aloud. List again after a week. Affidavit be filed by then.
Yes.
In the meantime, I'm going to join my lord.
No, let me file affidavit then lordship.
No problem.
He cannot have all the benefits all the time.
No, you can join. What is there? You can join.
That
Let
may
me
be,
find
that
my-
observation may be
No,
given.
lordship, let me find my affidavit. Let me bring this order through an affidavit before the honorable court.
No, you bring
He
it
has
also.
objected to it, lordship. I have, that was my submission. Now he has objected. He has gone for everything, lordship. Let me file my affidavit, then lordship.
No, I'm not saying anything about
Yes,
that.
yes.
It's all up to
Yes,
you.
that is the.
Okay, next.
Marshal.
In this case also, I need some accommodation, lordship. This matter was earlier, lordship, Mr. R. Majumdar, he was appearing all the time. He has said that some appeal has been filed. So I couldn't find out who is the number of the appeal, lordship. Lordship, kindly give me some time, lordship. And to also to know what is the present status of this appeal.
Okay. Mr. A. Chetri, isn't it?
Yes.
Learned counsel appears for the petitioner and Mr. SM Chisti, learned counsel appears for the respondent.
Four.
Respondent number 4
Yes.
and seeks for how much time?
2 weeks time, lordship.
2 weeks time
Yeah.
to obtain instructions in the matter. Anything you want to submit? Respondent number?
5.
Ms. RM Barwal, counsel appears on behalf of Mr. A. Chaliha, who represents the respondent number 5. List again after 2 weeks, date to be fixed by the ministry.
In the last occasion, 11/6, madam. File affidavit, madam. Since 2023, madam.
Respondent number 5 has filed.
my lord. Headmaster,
Headmaster. Department has not filed.
not filed yet. Is a cover case, my lord.
Huh?
Is a cover up case, my lord. Can you see? Page?
Cover up case.
Yes, madam. Can you see? page?
Covered case or cover up case?
Cover case.
Mind you, that might carry some other meaning also. If you say
Yes.
cover up case, but if you say cover up case, that means something is,
Sorry.
whole story is not there. Okay. What is
Can
your
we
case?
see page 57, 58? The judgment, my lord.
57.
57, my lord. And my lord, relevant portion, my lord. 59, page 59, my lord. Paragraph 657, my lord, can you see? As already noticed, section 4(1) of the Act. Petitioner is similarly situated. my lord.
Anyway, today it is listed for orders, isn't it?
Yes.
You have not received instructions. Will-
Instruction is received, but my lord, it is not the full, my lord, it is partial instruction is.
Why,
Sometimes is required, my lord.
why you receive only partial instruction? They are sending instructions in installment. Huh?
No, my lord, here, partial instruction. My problem is that the Provincialization Act 2011 was struck down. my lord. So now they are sitting in the provincialization under 2011.
All right, you give me instructions. I'll give you some more time. Mr. A.J. Apia, learned counsel for the petitioner, is present. And Mr. U. Sharma, learned standing counsel, Secondary Education Department, submits that he has not received complete instructions and therefore pays further 3 weeks' time. Who appears for number 5? Respond number 5.
Headmaster,
Who is appearing for that? No one. Affidavit is filed otherwise. Next.
she was there. Sometime earlier, she was there, madam.
She was there but left.
I left.
Okay, in view of above, list this matter again after 3 weeks. On a date to be fixed by the registry.
The date may be fixed. madam.
Secondary Education Department shall file the affidavit on or before the next date.
Date
Registry
may
will,
be fixed.
registry will fix it after 3 weeks. Okay.
My please. This matter pertains to non-payment of salary. A detailed report is as page 68.
Any response?
Oh.
Anyone appearing? Who's respondent number 5?
Service to complete upon.
Headmaster.
The school headmaster is. Where the petitioner is employed. Service is complete.
Please write down. As per the Lawazima Court's order dated 1/4/2025, Notice has been delivered to the address of respondent number 5. And therefore, notice is found to be complete. And therefore, service, not notice, and therefore service is found to be complete. Instead of having regard to the same, notice upon respondent number 5 is accepted to be complete. Mr. U. Sharma, London Standing Counsel. Secondary education, praise for and is granted. How much time?
3 weeks time.
3 weeks time to obtain instructions in the matter.
Date will be given. The salary relates to the year 2014.
List this matter again after 3 weeks on a date to be fixed by the registry.
Lord, in this case, I am paying on behalf of NJ Khatuni, my lord. When I am paying for electoral accommodation for today, my lord.
Review. How much time do you want?
But for the day, my lord, any date, my lord, next week.
Next week.
Next week, any date, my lord.
Mr. N.J. Katania, London Standing Counsel, Secondary Education Department, appearing for the review petitioner. He said to have some personal difficulty to appear before the court today. On a prayer made on his behalf. The matter stands adjourned. To be listed again after a week on a date fixed by the registry. Oops.
14 and notice, I need some accommodation, I need some, there are week time to get the instruction, but I have not received the 14 and.
Okay, Mr. SMT Chistry Lanet Counsel appearing for
Respondent 1 and 2. 1 and 2.
the respondents seeks a week's time for obtaining instruction in the matter.
May I please, Lordship, can the date be fixed?
Registry will fix a date. In view of above, list this matter again after a week on a date to be fixed by the registry.
See also, Lordship, I need something, Lordship.
You appear for which respondent?
Sole one response, sole respondent.
After 1 week?
Yes, yes. After one.
Okay, similar order.
Apply.
My lord. This matter, my lord, actually this matter was heard earlier. Written argument was also submitted. Somehow judgment could not be passed, my lord. So let it come for admission, my lord. Within a short date, let it come for admission.
Admission or regular hearing?
Admission, my lord, not admission hearing.
When do you want it?
Admission, because regular hearing again it will take so many things. But
Okay.
it is a case where one IIT students had been punished, imposed some punishments. So now if it is no need to delay the matter.
Okay, when do you want it? After 2 weeks?
I will do it up to 2 weeks. Date may kindly fix, my lord. One date.
Date they'll give you, registry will give you,
Date.
so that we don't jumble up all the case in one day, no? As paid for the parties, release the matter for admission after 2 weeks on the date to be fixed by the registry.
My lord, in this case, may be allowed to file affidavit lordship on behalf of respondent number 8 lordship. Here in this case, my lord, first wife and second wife, I am petitioner before your lordship is first wife, and he is second wife. And first wife, my lord, once gave her, my lord, liberty to extract, my lord, pension and to give me my share, my lord, but subsequently he cheated the petitioner. This is not correct, lordship. Every month she is paying lordship, last month also paying. Lordship, I pray, lordship, I may be allowed to file affidavit on that. Every
Short
month.
date. Short date.
Short date, lordship, only.
1 week, 1 week.
After I lordship, it's from Highland and the lordship fees annual. She is paying lordship, I have a receipt of all this. What my landed this Okay, month after filing this case, my lord, if she is paying, my lord, I will also take instruction, my lord. Lordship.
Yes, take instructions.
Every my lord. She is paying lordship every month. I have a receipt of that. If this allegation is there, lordship, I will produce all receipt and bank statement. I may be allowed sometime to enable me to file it.
All right, as paid for by as paid for by Mr.
K. Majumdar.
K. Majumdar, Learned Counsel for respondent number 8. 2 weeks time is granted for filing counter affidavit. List again after 2 weeks on a date to be fixed by the registry.
So here we have issued a compliance order. I will bring it with an affidavit lordship any day next week.
Okay. Mr. SMP Chisti, Learned Counsel for the respondent, submits that the orders of this court has been complied with, and he may be given a week's time to bring on record the compliance order. Praise aloud. List again after a week on a date to be fixed by the registry.
My pleasure also. I regarding implementing the respondent with SC ERTS party respondent number 4 also in connecting with petition. The Lordship has directed by the order dated 18/6/25.
Where's the order?
Order was not, order is not annexed also.
Not annexed.
I have mentioned in para.
See, SCRTU has to be represented by somebody, director.
SCERT,
Represented by?
its director also.
As respondent number 4.
Yes, sir.
Any objection? Okay. How many petitioners are there?
Petitioner are also 21 numbers
What is the relief you are seeking otherwise?
to get admission in BA program lordship. Earlier, the cutoff marks was 60 or 50 lordship, but suddenly it was increased to 90 or 85 for reserved category lordship, unreserved category.
What Miss
P. Soharia.
P. Saharia, Learned Counsel for the applicant, who submits that by filing this application, the applicants seek impleadment of State Council of Educational Research and Training,
Yes.
represented by its director, as respondent number 4 in the writ petition. To stop, the Learned Counsel submits that in pleading the state entity is necessary for effective adjudication of the controversy, and that the same would not change the nature and character of the writ petition. Your good name?
RC Alam.
Mr. R.C. Alam. Learned counsel appears for the. You represent which respondent?
GU Guwahati University.
Guwahati University. And submits that court may pass appropriate orders as it deems fit. For considering the submissions made and the application. And on perusal of the application. The prayer for impleadment of SCRT represented by its director is hereby allowed. I stands disposed of. Then in the main writ petition is right, in view of the order passed today in ISC number 2404 of 2025. The director, no, SCRT, give the full form. Represented by its director is hereby impleaded as respondent number 4. Petitioner shall file amended post title with the proper address of SCRT in 2 sets within a period of 3 days.
Yes, sir.
Whereafter registry shall do the needful. Mr. Pukan, we have impleaded SCRT. The SCRT has been impleaded as number 4, respondent number 4.
We don't have any of this.
Okay, next para. Issue notice to the newly impleaded respondent number 4, returnable by 3 weeks. Petitioner to take steps for service of notice upon the respondent number 4 by registered post with ADD within 1 week. List again after 3 weeks. Or a date to be fixed by the registrar.
Fabulous.
Hmm.
Lord, so far as WPC number 3658/2025, my lord. The await service report in respect of respondent number 4.
Yes.
And in respect of other WPC, my lord, they have not filed the affidavit as of now. Then petitioner.
So we'll list again after some time then.
And today it is, my lord, in consideration of interim order was it's there. Notice on interim order was there, my lord. We have filed one additional affidavit also to bring on record certain documents, item WPC 3658, my lord. In this matter, my lord, some time is required for instruction and to file our affidavit. In the impugn order, my lord, they have taken a stand that the petitioner was above 57 years of age. Therefore, my lord, he could not be given the charge of the principal of the school, my lord. And to, my lord, reply that, my lord, we have filed an additional affidavit, my lord, in order to bring on record that in respect of, my lord, another school, my lord, there was a litigation between the two petitioners. Next, additional affidavit, my lord. Page, my lord, you should find 56, the order in WPC 342423.
Yes. What happened in that case?
In that case, my case is disposed of, my lord. In both the petitioner and the private respondent was, my lord, about to retire within 1 year of service. And the respondent number 4 in that private respondent
well, not 4, private respondent number 5 was given the charge of the principal of that school, my lord. And the petitioner has put to challenge that. He was also about to retire within 2-3 months later, my lord. And thereafter, my lord, this petition was disposed of with a direction to consider the, my lord, the seniority and pass the order. Accordingly, my lord, both the petitioners, after the retirement of the respondent number 5, the petitioner of that petition was also allowed to hold the charge of the, my lord, principal. And I have annexed the seniority list at page 54 of that school, my lord. Seniority list, you also will find that were about to retire. Date of retirement was 31/12/2023, and petitioner was 28/2/2024.
That was in respect of another school.
Yes, they have taken a stand
Now
in
that-
case of my
Okay,
lord.
just a minute. Now, regarding that 3 years remaining,
Yes,
is it notified by some notification or how they?
it is there for direct recruitment. The post of principal, my lord, regularly as per rule, my lord, it has to be filled up through direct recruitment. And for the purpose of direct recruitment, my lord, 3 years is the minimum should be there.
3 years means what?
Yes, retirement, before retirement, there has to be 3 years of service.
For direct recruitment?
Yes. It is as per rule 12, it is the direct recruitment post of principal. And the candidates who will apply, they should have the 3 years of minimum service remaining in the.
What is the other condition for direct recruitment?
This is one of the condition. Another condition is master degree and B.Ed, my lord.
Oh.
And nothing else. So 17 years of teaching experience in case of graduate teacher, and postgraduate teachers, so 15 years of teaching experience. That is for the direct recruitment.
17 and 20 years.
17 and 15 years.
17 and 15
17
years.
for the graduate teachers,
Okay.
and for postgraduate teachers.
And they should have a balance of 3 years.
Yes.
For direct.
For direct recruitment.
But for promotion, that is not the
There is no
condition.
promotional scope for the post of principal in higher secondary school, my lord. There is no promotional post. Only the up to headmaster and vice principal is, my lord, promotional. Principal is direct recruitment.
No, in your case, what
And
is?
for the purpose of giving the charge, my lord, they usually have practice to give the senior most teacher
Okay.
having the qualification.
Your case is regarding higher secondary or high school?
Higher secondary.
High secondary.
Higher secondary.
High secondary means principal.
Yes. And I'm the senior most, but I have not been given, my lord.
No, for in charge,
Yes,
not for regular.
not for regular.
Well, he is actually over age.
It is
He has already crossed the 57 years, which is the.
Overage,
norm.
already overage for being in charge.
Yes, my lord. As
You see-
the norms are followed in the recruitment of principal, same as in charge principal also, my lord. So here, my lord, 57 years, at the time of my lord,
So what do you say about this additional affidavit? Documents in the additional affidavit? In case of 2 other similarly situated persons. One was given the benefit, he retired, then the other one also got the benefit.
Even retirement 1 month before the
in
retirement.
this regard, my lord, I have to take instruction from the department, my lord.
You take instructions within 1 week.
Yes.
We had made an observation that interim will be considered on the next date.
Yes.
So we'll extend that. You
Yes.
take your instructions.
Yes, yes.
That was the order dated 8/8/2025 of the Lavazima Court. And accordingly, matter stands adjourned for a week to await service report. Stop. Similarly, Mr. U. Sharma, Lanet, Standing Counsel, Higher Secondary Education, shall obtain instructions on the claim made by the writ petitioner, as well as on the additional affidavit filed by the petitioner, whereby it is stated that in a case of similar nature, persons who hardly had who did not have 3 years of remaining balance of service were allowed to hold the post of principal on in charge basis. Stop. Therefore, the respondents cannot deny the same benefit to the instant petitioner for not having 3 years of balance service. List again after a week on a date to be fixed by the magistrate.
Friends. Your Lordship, I seek the court's leave to appear as petitioner in person. Your Lordship, this matter was moved on 28/7 and 25, and Your Lordship has passed an order. And in compliance with that order, Your Lordship, I have taken a step for service of notice upon the respondent number 5 through postal Talabana. And Your Lordship, I have also filed the amended cost title, and the copies thereof has been duly served with the respondent, Your Lordship.
This was just a few days back, isn't it?
Your Lordship, yes.
It's come again. So service is not complete in respect of respondent numbers 1 and 2.
No, sir, no, Your Lordship, respondent 5, principal, BRM.
Oh, and 5. 5, okay, 1 and 2. State government. And 3, 4 is the university, okay. 5 is the principal.
Yes, Your Lordship.
You have filed affidavit.
Millard.
You have filed.
I have last Friday, Millard, I have filed affidavit in office.
You have received the affidavit?
Yes, Your Lordship, I have it.
What do you say? You want to file a rejoinder?
No, not required, Your Lordship.
You want to file a reply to that?
No, Your Lordship. Because in that affidavit opposition, they took the stand that my answer script has been evaluated properly. But this is not possible with respect to answer to question number 2D, Your Lordship.
2D?
Page 74.
Why is that?
Annexure, Your Lordship, 10A.
No. Why is that not possible?
Because, Your Lordship, in ordinary parlance, Your Lordship, our answer is right or wrong can be identified by 2 symbols. Cross symbol for wrong answer and right symbol for right answer, Your Lordship. But this particular answer, there is no such symbol, either cross symbol or right symbol, indicating that it has not been evaluated, Your Lordship. Taking the fact that it has undergone the process of re-evaluation as well. And with respect to the MCQs, Your Lordship, I have the source with me, Your Lordship.
You are saying answers to question number 2D.
2D. It contained 2 marks, Your
What about 2E?
2E, it's fine, Your Lordship.
No, there is no symbol like you said. It should be X or tick mark. It is not there.
There is 1 mark is there, Your Lordship.
Where?
Page 76, Your Lordship.
Oh, below?
Below, Your Lordship.
This is mark.
The mark, and below it, there is 1 mark with a round symbol, Your Lordship.
This is the mark.
Mark, Your Lordship. But with respect to 2D, there is no such mark. If my answer is wrong, Your Lordship, they should have marked it as wrong and put it 0. I would have no grievances, Your Lordship. And with respect to, Your Lordship, answer to question number 5 or A, it has been evaluated, but no mark has been provided, Your Lordship. It contains 6 marks. Page 92, Your Lordship. It starts from 92 and continues till page 95.
Anyway, I think we are more concerned with the principle. We are not here to check physically whether tick mark is there or not, or whether marks is. So now, as far as the principle is concerned, whether he's a necessary party. Or not. Evaluation has been done by the university, isn't it?
Yes. But it's in the principal's college where I wrote the examination. It's the examination center, Your Lordship.
Surely. We have to write somewhere, isn't it? So, who's for the department? Anything to say? Hmm? You're a formal party.
My lord, the principal of PRM Law College, proper and necessary party. So, my lord,
Do we wait for the service report then? What is to be done? You have taken steps on which date?
Your Lordship.
Notice was issued on 4/8. Monday. Last Monday. Why don't you do one thing? Why don't you serve by way of Dasti?
Dusty, yes,
Can
Your
you
Lordship.
do?
If it is granted, I will.
Within 1 week you serve?
Yes, Your Lordship.
Parties are represented by the respective councils except for respondent number 5.
Your Lordship, may I make one prayer, Your Lordship? Your
Yes.
Lordship, by the next hearing, Your Lordship, I have a small prayer. There are similar issues were already decided by the Honorable Guwahati High Court, this court, Your Lordship, in writ appeal number 61 of 2019. There was a candidate who appeared for the written examination for the post of Inspector of Excise under this one, APSC. Your Lordship, he obtains, that means some marks, and thereafter he filed an RTI. After perusal of the answer script, Your Lordship, he claimed that he is entitled to 12 more marks. Therefore, he challenged it before this honorable court, and the learned single judge has directed the Vice Chancellor of Cotton University to form an expert committee in order to evaluate the answer script. And
Okay.
after.
See, we'll consider that on the
Yeah,
next date. As of today, we'll allow you to give that serve notice to respondent number 5 by Dasti.
Yes, Lordship.
That'll be easier.
Yes, Lordship.
Because AD card may not come back also, we don't know.
Oh.
Accordingly, the petitioner is allowed. Now, what did I say last? Respondent number 5, full stop, the rest you cut. It is seen that the respondent numbers 3 and 4 have filed their affidavit of opposition on 8/8/2025. Mr. S. Bhuya, Learned Standing Counsel, Higher Education Department, suppose that the department is only a formal party. So since notice upon respondent number 5, since service of notice upon respondent number 5 would be necessary, having regard to the nature of case projected by the petitioner in person, the petitioner in person is permitted to serve notice to respondent number 5 by way of Dasti within 1 week from today through the registry of this court, and thereafter file an affidavit as proof of service. List the matter again after a week.
Date may be fixed, your lordship. Well,
They'll fix after a week on a date to be fixed by the registry. Okay.
deeply obliged, your lordship.
Most of
Your lordship. Hello, the petitioners are retired employees of Oil India Limited. They are seeking pensionary benefits as per the old pension scheme.
We are out of time today. What to do?
Yes, now it will take some time, and further, my lord, this is a bench 3 matter, I think wrongly listed before this.
Bench 3.
Pension matter, my lord. It's a pension matter of Oil India employees, my lord. They are
Oil India, okay.
My lord.
Okay, it is submitted at the bar that the matter pertains to bench 3. Registry to verify and list accordingly on priority basis. Okay. Right. When do you want it?
Ninth. On 9th
9th of September.
9th of September. You want a date?
Tuesday.
Any urgency?
2020 meter lordship, it was already heard and pitched for judgment lordship, but it was later on released lordship. Honorable Mr. Justice Gami has pitched this matter for judgment lordship. 2020 selection and appointment laws.
Then you have a date? September. Second week.
9th of September.
What about 11? Oh, yeah, 19? 16? We'll have it on 16. Seeing the calendar, we'll fixing it. Okay. As paid for by the parties. Is the matter for hearing on 16th of September. Most last listed in 2023.
After motion, it has come for the first time.
So if it regularly comes, then you get instructions. If it comes after a long time, then you don't get instructions.
There is also no instruction.
How much time?
After 2 weeks, also any day.
All right,
That's
as
why
paid
give
for
it
by
time.
Ms. S. Sutiel and its standing counsel, Elementary Education Department. 2 weeks' time is granted to obtain instructions in the matter. And also to file counter affidavit. List as even after 2 weeks on a date to be fixed by the registry. Mr. A. Dekal and its counsel appears for the petition.
The date in the month of September, also any day. September after 16th of
September?
Sufficient time they will get.
No, I'm not giving a date because you see, it becomes difficult.
2023 matter, let's say.
I know.
That's although there is supposed to matter listed after 4 weeks, but matter is not listed. That is the difficulty, let's say.
Then
While
come, we'll
notice
come.
is issued, there is a direction is given after 4 weeks. But even though that's.
In that case, you make it 4 weeks. Instead of 2 weeks, 4 weeks. List again after 4 weeks on a date to be fixed by the registry. They will fix. Yes, next.
May I please, your lordship? This is third litigation lordships, which is fighting for their salary
Salary.
component lordships. the fact is that the school in question is a minority school. It was established in 1956, and the minority managing committee, they are as such administering the same. 1976 rules that came into force, that is Assam Aided Higher Secondary High and Middle School Management Rules was framed in 1976. When inspector of the school dissolved the managing committee and constituted new managing committee as per the provisions of Assam Education Secondary Education Provisions Act and Assam Aided Higher Secondary Middle School Management Rules 1976.
Mr. Bhuya, will
It was challenged.
readings are complete?
No, madam.
Leadings.
No, madam, the instruction is awaited. Instruction is awaited.
The notice was issued, Lordship. What
we will
instruction,
file
I
our
don't know,
affidavit.
Lordship. Notice was issued on 13/10 or 23. They are not taking any steps, Lordship, for filing affidavit also. By imping order, they rejected.
Respondent number 4 has filed.
Respondent 4 and 5, the school authority has filed
Managing-
the affidavit.
Hmm.
But we are fighting for our salary, Lordship, since 2013. This is third litigation.
Mr.
By
Sharma,
the specific directions, they came with a wrong order.
Provincial school and moreover, madam, they are the honorary teacher, madam.
That is not correct. That's why that school is a minority question. There is a judgment of the Honorable Supreme Court.
you file your affidavit, then you argue. Or without affidavit, you'll argue.
No, no. We have to file our affidavit, madam.
Oh.
So sometime is required.
When will you
Only
file?
short week, Lordship, 2030.
When will you file?
It's maybe,
3 weeks time.
Lordship, my prayer is 2 weeks. I am not getting salary since appointed in 10 and 8 to both teachers.
You're not getting salary since when?
So from date of our appointment, because they have not approved our appointment letter, because the managing forwarded for approval, they have not accorded approval. That's why we are not getting the salary. Similarly, teachers appointed by the managing committee, they provided the salary.
Okay, so since 2009, without salary, you're surviving.
Yes,
So you can survive another 3 weeks.
but
There's no issue.
2013, I am fighting for 2013, but came before also 2013, Lordship.
We'll give some time to Mr. Sharma.
Yes.
He's got so many cases to handle, so he's quite
Lordship, but
tied up.
there is urgency because they are not getting salary, Lordship.
Okay. Mr. F.U. Bhuya, learned counsel appears for the petitioner and submits that despite several chances given, the respondent department is not filing counter affidavit. And the petitioners are without salary. Petitioner is without salary since the year 2009. Mr. U. Sharma, learned standing counsel, appearing for the what is this? Elementary. Secondary Education Department submits that he may be granted 3 weeks' time to obtain instructions and to file counter affidavit. Madam, your name? Miss? Your name? K? Miss K Yadav. Learned counsel appears for respondent numbers 4 and 5. And submits that affidavit is already filed by the said respondents. Next para, considering the submissions made. 3 weeks' time is granted as a last chance to Mr. U. Sharma, learned standing counsel, Higher Education Department, Secondary Education Department, to obtain instructions and to file counter affidavit. List again after 3 weeks on a date to be fixed by the registrar.
I'm praying for fixing a date, Lordship.
They will fix a date, okay?
Date.
Because we are not expert. The experts will fix the date.
Okay.
Okay.
Is a part Lordship will provide.
Next case.
Lordship.
Yes.
Lordship, on last occasion, the respondent authority has to file an additional affidavit, but they haven't filed yet. Notice was issued.
Additional affidavit.
Yes, your Lordship, but they haven't filed yet, the respondent authority. The notice was issued on 6/11/2023, your Lordship.
BTC.
Yes, your Lordship.
No one is there for BTC today. BTC. What is the matter regarding?
The matter pertains to non-payment of arrears salary and current salary, Your Lordship.
Petitioner is working as
The petitioner has been working as
teacher,
a mother teacher.
mother teacher.
Yes, Your Lordship, mother teacher.
What is mother teacher?
The petitioner this is a third time litigation, my lord.
Sorry?
This is a third time litigation by the petitioners, my lord.
Okay.
Yeah.
No, what is the term mother teacher?
Teacher. Those who are appointed by the BTC authority to teach the lower primary section. That is like Anganwadi worker like that.
I see.
Mother teacher, but
So this is in BTC area.
it is under BTC area. The first order was passed, that is on page 66, where there, after that order, that was order passed on 10/4/2012. That is Annexure 3, my lord. Annexure E, page 66, my lord. 66. After that order, the petitioner received 36,000 per person as an area salary in 2015, my lord. Thereafter, again, after their salary, regular salary is not paid, thereafter they have approached before this court by filing another writ petition. This is an association, my lord, all BTAD School Mother Teacher Association, and another writ petition was filed. And after that writ petition was disposed of in the light of the earlier order, but till date, they have not received area salary and current salary. And this is my submission. And the page 72, my lord, where this court observed that paragraph 7, this court in the earlier round of litigation is calculated in the order dated 10/4/2012, passed in WPC number 864/2009, had come to the categorical finding that the engagement of the member of petitioner association as mother teacher not in dispute. And in fact, the BTC authority had admitted to such claim regarding engagement. And after this order, my lord, they are expected to receive their service, and some of the mother teacher who got the salary, area salary and current salary, but this petitioner is not received the area salary, also current salary, except those 36,000 per person in the year of 2015, my lord.
We'll do one thing. We'll list this again some other day.
Yes, my lord.
Since there's nobody from the BTC. By filing this writ petition, the petitioners claim their current and area salary in the post of mother teacher. And this is the third time they are before this court. Madam, your good name, Miss
Mrs.
MS Bujur. Mrs. A. Bujur Barua, learned counsel, appears for the petitioners. But none appears for the what is the respondent? BTC.
BTC. Earlier occasion, B. Sodhi was appeared, my lord, on last occasion.
Stop. As such, let the matter be listed again. After the week, on a date to be fixed by the registry. All right. You are there? Now, what is your role here?
under BTC area, they separate something.
Okay, Ms. S. Supiel and Standing Council Elementary Education appears for the Elementary Education Department and submits that the BTC is the main respondent here. And the Elementary Education Department has not much to say. Okay. How many left?
May this is lordship. This matter may pass over for the day lordship.
Okay, as paid for by the 11th Council for the petitioner. Matter stands passed over. 27.
The petitioner before the lordship is LP school teacher. So from 19 to 24, about 62 months, my lord, his area salary was not given. What happened, my lord? Sometimes some months salary has been given, and again some months is not given. This is the position, my lord. And your lordship was pleased to issue notice on 5/2/2025. On 28/3, my lord, there's short time for instruction. And now your lordship will again see order dated 16/5/2025. They prayed for time. Again on 2/26/2025, my lord, they prayed for time.
This is
For instruction.
the main respondent is Kabyang Law.
Kabyang Autonomous Council.
What is your instruction?
As he has been alleged for financial irregularity, lordship has been suspended.
My lord, I have been suspended after filing this writ petition. That is another aspect of the matter. But what I have performed my duties, my lord, that areas I am entitled to. Suspension will not be answer.
Since when?
My lord, since 2019 onwards.
Your salary?
Yes, my lord, for 62 months, my lord. What happened, my lord? In some months, my lord, in particular year, supposing 8 months has been paid, your lordship would be pleased to come to para 3 of my petition. I have given detail, case 5, my lord.
Anyway, we'll grant them some time
My
to
lord.
get instructions.
My lord, my humble submission before your lordship. I am a LP school teacher, my lord, 4%. It may be given last chance, my lord, otherwise they will not file a video. And today they have come with a suspension order. And that's not the proper way, my lord. Suspension order is not the instruction. What about my area salary? They have to file affidavit. What they want to say. So, as 3 dates already taken, my lord, your lordship would be pleased considering the 4 teachers, my lord.
Mr. M.A. Sheikh,
Last chance, my lord.
learned counsel appears for the petitioner and submits that by filing this writ petition, the petitioner has claimed payment of area salary for 62 months.
Amounting to 26 lakhs and odd.
Amounting to rupees 26,04,000. So he also submits that despite notice having issued
5/2, my lord.
on 5/2/2025, the respondents have not filed any affidavit. Today, Miss
As can private.
S. Kemprai, Learned Standing Council, KAC. Submits that on account of certain financial irregularity committed by the petitioner, he has been placed on the suspension with immediate effect. White order dated 19/6/2025. Stop. However, the fact remains that
Lordship departmental proceeding has been initiated.
Okay. However, the fact remains that the petitioner's claim for area salaries. And therefore, the respondent authorities would have to respond to the same. To stop, the details of the claim made by the petitioner is already highlighted in paragraph number 3 of the petition. Stop in view of above. How much time?
3 weeks, sir.
3 weeks' time is granted as paid for to obtain instructions in this regard and to file counter affidavit. Mr. S. Barua. But I'll record your name.
Yes, sir.
Mr. C. Barua, Learned Standing Counsel, AG Assam, APS.
Number 6.
For respondent number 6 and submits that respondent number 6 has no role to play
Area salary. Area salary part we do not have.
in respect of the claim for, in respect of the claim for area salary. Ms. Suthi is also there? Number? Mrs. Suthi, Learned Standing Counsel, Elementary Education, yes, for respondent number 1. 1 and 2. Next para, list this matter again after 3 weeks on a date to be fixed by the registry.
Registry will fix the date. My lord, my prayer before your lordship is this: three dates have been given to the council, my lord. So my lord, it may be given as a last chance, my
No,
lord.
no,
Otherwise,
Mr.
it
Sheikh,
will not-
Mr. Sheikh,
My lord,
let us wait for some time. Your
My-
case was filed this year only, February.
my lord,
Let us give them some time. Reasonable time.
my lord,
We'll consider your prayer next time.
my lord. Oblige, my lord.
Versus, I am on of the petitioner. 2 weeks time may be given for filing a counter affidavit.
Rejoinder, rejoinder affidavit.
Reply.
Ah,
A reply of the.
counter will come from that side.
Yes, reply.
If you file counter, that means
A reply of the affidavit.
court is not required.
On the point of maintainability.
Okay.
Okay.
As paid for by the learned counsel for the petitioner, 2 weeks time is granted for filing rejoinder affidavit. On the affidavit of opposition filed by the respondents. List again after 2 weeks on a date to be fixed by the registry.
Oblige.
Oh, no, this is a covered case by Ajay Chaudhary's case, my lord. He was placed on the suspension on 17th of March.
Ajay Chaudhary.
No DP has been initiated till date, my lord.
But who's there for the other side?
Education department as well as my lord, BT,
Education means what?
secondary division.
Secondary education. But again, BTC, isn't it?
Yes, my lord. Possibly take up the matter on Thursday, my lord. So
Not
that,
Thursday, we'll say after a week.
my lord, we don't fixing that, my lord, he's under suspension since last 5 months, my lord.
No, we'll,
No,
they'll reach Mr.
they have passed an order, my lord, the
All-
inspector of schools.
Although Mr. I.H. Saikia, learned counsel for the petitioner is present. No one appears for the BTC respondents. The sub-claim of the petitioner is that he has been kept under prolonged suspension and in violation of the apex court decision in
Ajay Kumar Chaudhary,
Ajay Kumar Chaudhary versus
Union of India,
Union of India,
reported in 2015 7 SCC 291.
2015,
2015 7 SCC
7 SCC
291.
291. List again after a week on a date to be fixed by the registry. If the BTC remains unrepresented, court may consider proceeding with the matter on the basis of materials available on record.
Oblige.
May I please your lordship? Your lordship, in the last occasion, notice has been served.
And the respondents, they were told to file a reply to it.
There's no affidavit till now. You're for the petition, isn't it?
Yes, Your Lordship.
Mr. How much time? Parties are represented by the respective councils. As paid for by Mr. U. Sharma, learned standing counsel, elementary education. Elementary, is it? Secondary education department. Further 3 weeks time is granted to obtain instructions and to file compact affidavit. List again after 3 weeks on a date to be fixed by the registry.
Item number 32 and 33, these are bench 3 matter. Not wrongly listed before bench 2 matter.
My lord, maybe, my lord, otherwise also they are supposed to file affidavit. Maybe fix a date to file an affidavit, my lord.
No, if it's bench 3, I should not fix a date. It will not be proper. It is submitted to the bar that the matter pertains to bench 3. Registry to verify and list the matter accordingly on priority basis.
My lord, the matter has been listed, my lord, on the basis of my application before the registry, my lord. Maybe, my lord, in the coming week, my lord.
I said priority basis will come.
The petitioner is behind the bar, my lord. They are in the BSF, my lord. They have been, my lord, sentenced, my lord.
You make one more entry and write bench 3.
My lord.
Okay. This one?
May I please, Your Lordship? Lordship, we need time for 3 weeks for filing additional affidavit.
You're for the petitioner, isn't it?
Yes.
Why do you want to file additional affidavit?
We have to file extra documents regarding the matter.
Extra documents.
Yes. Additional affidavit.
What sort of extra documents?
Relating to petitioner service matter.
You feel that I'm asking too much questions,
Yes.
but you should at least tell us what you want to file. Normally, you don't give time like that, no? Unless you say that there's some developments.
Yes, yes.
I need to incorporate that. Okay. As paid for by the learned counsel for the petitioner, matter stands adjourned for 2 weeks
Yes.
to enable her to file an additional affidavit to bring on record certain materials which is relevant to the case, which is accordingly permitted by this court. Yes. List again after 2 weeks on a date to be fixed by.
Bless.